Thank you so much. This is the first time I'm here. Thank you. Yes.
May it please, your Lordship.
Yes.
Lordship, I beg to mention here in item number 14,
14.
Lordship. Here the state respondent has filed the affidavit in additional affidavit.
Yes.
So I have prepared the reply. However, I'm yet to get the signature of the opponent.
On the last occasion only you had taken time, Nikya, or what? Wait, I'll just see 14 once. 14, yes. Reply was not filed.
Yes, yes.
It was by you.
Yes, yes. We have prepared, but we are yet to get the signature of the opponent, Lordship. Here, Lordship, as per the dated 11/3/2025 of this honorable court, the state respondent is supposed to file. Yes, the state respondent is supposed to produce the relevant records connected to the issuance of the work order, Lordship. However, they have not produced that. So they have not filed all the relevant documents. So, Lordship, the state respondent may be directed to file all the records.
Someone is representing state. In item number 14, you are supposed to file some papers. 14.
Lordship, actually, I'm not in this matter.
Acha.
Yes,
It'll give you time to file your affidavit in reply.
Correct, Lordship.
And your reply will be based on their.
Yes, yes, yes.
So they have to.
Produce all the relevant documents.
That they will produce on the next date. You in the meantime file your reply.
Okay, okay,
Okay.
okay.
As prayed for by Mr.
W. Marshall Lodge.
Okay, so and so appearing for the. You are for respondent, you are for.
No, I'm for the petitioner.
You are for the petitioner. Petitioner. List the matter after 2 weeks.
Lordship.
In the meantime, Mr. So-and-so will file the affidavit in reply to the affidavit in opposition filed by.
Additional affidavit filed by the state, Lordship.
Okay,
Yes.
to the additional affidavit filed by the state. List the matter after 3 weeks or 2 weeks?
2 weeks, Lordship.
2 weeks. On a
Right,
date to be fixed by the registry,
Lordship.
or do you want a date?
No, Lordship.
Okay, on a date to be fixed.
Obliged, Lordship.
That's
May I please, my lord? Lordship, I beg to mention that hearing item number 21.
21.
21, your lordship. Lordship, I have some partnered matter in other court. So if this matter can be listed on Thursday, your lordship.
Okay, and there I think affidavit in reply is not filed. 21, right?
21, my lord.
Because on the last occasion, we are supposed to file.
I will not be filing any reply affidavit.
You will not?
Yes.
You will not be filing?
No.
Acha, but then it's already there in the records, it's already there in the last order.
Yes, I actually I saw time, but on going through the counter affidavit, there was no new factual evidence, so I feel that it would be
Not
the
required.
materials on record will suffice.
Okay. So, Mr. So-and-so, you are for the state?
I am for the state, my lord.
Yes. For respondent number,
No, all the respondents, my lord.
for the state respondents, submits before this court that he is not prepared with the case today.
Lordship,
And so he prays the case to be taken up day after tomorrow,
Thursday, your lordship.
Thursday.
Your Lordship,
Prayer is allowed.
the interim, there's an interim,
Okay.
then
Prayer is allowed. List the matter on Thursday. Interim order passed earlier shall continue till the next return of
I'm
the
okay.
date.
Deeply obliged.
My please, Lordship, I'm filing, I beg to move on unlisted item, IA criminal in bill application 4 of 2025. On 2 May 2025, I was granted interim bail order, interim bail, which
You
expire,
bring IA
IA.
for suspension of sentence.
I'm praying to regularize my bail order, interim bail order, which
Okay.
expires today.
Acha, you have an interim bail order.
Yeah,
It is expiring today.
Yes,
Why,
madam.
it should have been listed otherwise.
yes, my lord, since it was on summer vacation, I could not file.
Acha,
So,
okay, let the matter be called up at the end of the list.
yes, my lord. It is item 4 of the regular course list, but it can be taken up, yeah. after review.
4, your matter is already there.
Yeah, it's already listed, but I could not file the IA on time. I'm
Acha,
filing only today.
let the matter be reached. I'll
Okay.
see what has to be done.
Yes, Your Honor, highly obliged.
May I please, your lordship? Lordship, I beg to mention hearing item number 19.
19.
Yes, your lordship, I pray that this matter may be listed after 2 weeks. I've taken consent from the opposite party, your lordship.
19 is, acha, it's a salary matter. Okay. Miss So-and-so, heard Miss So-and-so. Miss So-and-so prays that the matter may be taken up after
2 weeks, your lordship.
2 weeks. The prayer is not objected.
No objection.
Prayer is not objected by the state respondents.
Yes, my lord.
By the state respondents, list the matter after 2 weeks.
Lakshman.
Much obliged. May I please the lordship? Lordship, I beg to mention item number 20, lordship. On behalf 20. It's in the hearing. Lordship, I'm appearing on behalf of my senior additional AG LT Sangtam, lordship.
Acha.
Lordship, if this matter can come up after 2 weeks, lordship.
I think respondent number 2 was supposed to file additional affidavit.
They've already filed.
They have already filed. Acha, okay. You're for respondent?
For the state respondent,
Acha. Praying for 2 weeks time.
2 weeks time.
As prayed for by Mr. So-and-so, you have no objection?
No objection.
As for prayed for by Mr. So-and-so for state respondents, list the matter after 2 weeks.
May it please your lordship? Lordship, I beg to mention item number 13.
1 3.
Yes.
It's an IA. IA for what?
Lordship, we are yet to receive the service report as well as
Acha.
the
Huh,
affidavit in reply from the other party.
okay.
It is your honor.
Service is not complete, right?
Uh,
And this is IA is about what? Delay?
May it please your lordship, I've received the IA only 2 days back, and
Acha.
this IA is for condonation of supposed 47 days. So like my learned colleague has read, me also, I only received this 2 days back. So if this
You will
matter may be,
object to this?
your honor, I,
You have to
yes,
go through.
very likely, your honor. Kindly give me some time to go through.
Miss So-and-so, you're for the petitioner?
Yes, your lordship.
So-and-so appearing for the petitioner, prays for adjournment of the matter for 2 weeks. Mr. So-and-so,
Yes, your lord.
appearing for respondent, sole respondent?
Sole respondent, your lordship.
Mr. Appearing for so-and-so also submits that he received the papers only a day back. As such, he prays that he may be given some time to go through the same. Prayer is allowed, list the matter after 2 weeks. In the
Right.
meantime, if you file some objection, you can file.
Lordship, yes.
In the meantime, the sole respondent may
respondent.
file objection, if any,
Lordship,
to the IA, to the interlocutory application.
I'm obliged.
Much obliged. May it please your lordship? I beg to mention hearing item number 18 on behalf of my senior and newcomer. Lordship, my senior is indisposed, so can this matter be listed after 2 weeks?
Item number 18, you write. As prayed for by Ms. So-and-so. The matter may be listed after 2 weeks. On a date to be fixed by the registry. Or you can write Ms. So-and-so prays that her senior is indisposed. And as such, she prays for adjournment, matter to be listed after 2 weeks.
Lordship, I pledge.
Oh, you are there, no? She
Lordship,
is there for respondent,
for the state, Lordship,
for the statements.
I pledge.
For motion, item number 1.
May
There's
please, Your
delay again. Right.
Yes, Lordship, there's a 10 days delay and the IA is for condemnation of that 10 days delay, Lordship.
Okay. You are against DC's order, right?
Lordship,
Notice has to go. There is a sole respondent, I think.
my lord,
This is a land dispute.
this is a land dispute. I'm the first person to purchase the suit land. And purportedly, the respondent also purchased the same suit land from someone else.
I mean,
And
the same family members, right?
from the same clan, yes,
From the
Lordship,
same clan.
yes. However,
I think
instead of going
that-
into the merits, the matter was dismissed solely on technical grounds, Lordship.
And there was some settlement also was in the process.
Settlement was attempted, however, it was failed, Lordship.
It did not. Today to only notice will go.
Lordship.
Heard Mr. So-and-so. Your name please?
T. Kejal.
TKG. TKG for the petitioner. The instant case, this instant I is filed for condemnation of a delay of 10 days in filing the connected civil revision petition. Connected civil revision petition filed against the judgment and order dated 11/3/2025 passed by the learned Deputy Commissioner in Civil Appeal number 2 of 2023. Issue notice to respondent. Returnable by 3 weeks, 2 weeks.
Lordship,
Returnable
3
by
weeks.
3 weeks.
And Lordship,
The-
kindly permit me to serve notice through Dusty, since I don't have the
the
proper
petition
address.
to take service of notice upon respondent by registered post as well as usual process as well as by dusty mode. The petitioner, after service of notice, may file an affidavit
Lordship.
on services, showing service of notice by dusty. List the matter after 2 weeks.
Highly obliged.
For motion from the supplementary cost list, item numbers 22 and 23.
No counsels? Oh, yes.
My lord, I am appearing in this case,
Yes.
but unfortunately I was not able to go because a short notice yesterday only by an email. I think my learned friend Mr. Zohaib Hussain has filed his application from the ED site. From the ED site, Mr.
Yes.
Zohaib.
My lord, this is an urgent application, my lord. When the matter is taken up, I will make good why we are making this application. The person who was
The matter is already in the Mr. Zohaib. The matter is already been taken up.
Yes, my lord. Now please see, my lord, my application. This is the IA that I am pressing today, my lord, where I am seeking only a short clarification and placing subsequent developments on record, my lord. The subsequent developments are very critical for my lord's consideration. Now, please have the IA, my lord, for a moment.
Yes. You have prayed you have made 2 prayers. One
Yes,
is
my lord.
for urgent listing and the other one subsequent event.
Yes. Now, and my lord, may please see. I've also requested, my lord, to clarify. Please see the second prayer, my lord.
Hmm.
To
To clarify
clarify
for
that
this.
the orders dated 7th March, 13th March, 21st March, these are all interim orders which were extended subsequently, my lord. There is
Hmm.
no embargo on the exercise of power of under section 19 of PMLA upon fulfillment of the requisite conditions. Now, why I say that, my lord? Please appreciate what was the prayer in the petition in which these interim orders were passed. Please have the prayer page, my lord, at page 24.
Twenty-four of this IA.
Of the criminal revision, my lord, of the main petition.
Yes. Wait, there are so many. Hmm. Yes.
My lord will recall this. There are two petitions, one in which he is declared a fugitive economic offender, which
Hmm.
order was stayed, and the second petition where the NBW was challenged. So please see the prayer, my lord. Allow the instant petition, call for the records of the case bearing so and so, set aside and quash and rescind the impugned order dated 13th December 2024 by the learned trial court directing execution of warrant of arrest against the petitioner that was kept in abeyance and restore the interim order dated 5th September extended by order dated 1810 till the pendency of IA. Now please see, my lord, what was the order which was under challenge. That, my lord, will find at page 29. The order that was under challenge, my lord, page 29.
My lord, 1 second, before my learned friend start the case, as I'm appearing in this case, IA 13 of 2025 was served yesterday by an email to my junior, Mr. Khalid Mohammed, yesterday, and we have received. I think we have a right to file an objection in this case. So
No,
I know.
I'm not opposing his right, my lord, but I have to
Yes.
make out first. I have to make out that case so that my lords can pass appropriate orders. He can file a response, but interim order can be passed. Please see, my lord, what is my case? The case is simple.
No,
My
no,
case,
1 second,
Just,
you want
Mr.
an
Das,
urgent,
please
you want,
take
see, I have a right to file an objection.
You-
Thereafter, matter can be heard. This matter has been
Mr.
already
Das,
fixed on
please.
28.
I appreciate, my lord may kindly appreciate my learned friend may at least let me present the points before the court and then he can make a submission. The prayer, my lord, was for quashing of an NBW order. Power of NBW is under 70 and 73 of the CRPC. Now, please see section 19 of PMLA. Section 19 of PMLA is the power. Yes, yes.
Prevention of money laundering. You can read it slowly. Section 19 you are placing.
Yes, section 19 is the power of arrest, my lord, under PMLA by the assistant director, by the deputy director and other authorities under the PMLA.
Yes, I've got it. 19 is.
If the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by general or special order has, on the basis of material in his possession, reason for such belief to be recorded in writing that any person has been guilty of an offense punishable under this act, he may arrest such person and shall, as soon as may be, inform him of the grounds for such arrest. Now, 19 had nothing to do with the present petition. Present petition was seeking setting aside an order passed under section 73 of CRPC where NBWs were issued, non-bailable warrants. Now, my lord is aware, please have one compilation, my lord, that we have.
For his non-appearance.
For his non-appearance pursuant to several summonses issued. Several summonses issued, the court, because of his non-appearance, issued an NBW where, my lord, an open-ended NBW is issued for ensuring his presence. My lord is aware of the law that when an NBW is issued, I can't arrest him and take him for questioning and interrogation. That I have to produce him before the concerned court. There are two kinds of arrests, therefore, contemplated in law. Please have the judgment of Ajay Singh. Please have the judgment of Ajay Singh, my lord, at page 13.
Of the revision petition.
Of a compilation, my lord, my colleague may hand it over. It's Ajay Singh, my lord.
I don't think so. Your colleague is here.
I see.
There's no one here to place that judgment.
Very well. My lord, may only note, my lord, I am only pointing out that yes, my lord.
Hmm.
It's a 5-judge bench judgment of the Supreme Court. My lord, may see the citation 1952 2 SCC 421, Ajay Singh, para 20. This is just to show, my lord, that the code contemplates, the law contemplates 2 kinds of arrests. So the interim order passed in the present case was only with respect to execution of an NBW and the arrest thereof, not under section 19. So I am seeking please see para 20, my lord. Broadly speaking, arrests may be classified into 2 categories, namely arrests under warrants issued by a court and arrests otherwise than under such warrants. As to the first category of arrest, section 75 to 86 collected under so-and-so in chapter 6 of the CRPC deals with arrests in execution of warrants issued by a court under that code. Section 75 prescribes, etc., etc. Therefore, my lord, my submission is the power under section 19 was never ever under challenge in the present case. This is not an anticipatory bail application. Therefore, now please see the interim orders, my lord. The interim orders that have been passed from time to time, my lord. Please have, my lord, the interim order of 7th March 2025.
It's in the IA.
It's in the IA only at page 61. Where my lords have said, the learned counsel, Mr. Zotso, has entered appearance for respondents, ED, and has prayed for 4 weeks' time. Page 61, my lord. Prayed for 4 weeks' time to file his affidavit in opposition. Since he had entered appearance today for the first time, prayer is granted. Prayer is granted. However, the IA is fixed on 13th March 2025 for hearing on interim prayer till the next date, no coercive step shall be taken against the petitioner. Now, this order of no coercive step was only with respect to execution of the NBW and not with respect to the power under section 19. The reason being, an interim order is always in aid of a final relief, my lord. It is never intended to exceed or expand the scope of final relief, my lord. And I showed, my lord, what was the final relief? The final relief was to set aside the NBW. Now I ask myself, even if my learned friend succeeds in this petition and the NBW order is set aside, does it in any manner impact my right and power under section 19? The answer is no, because it's that is not the challenge which is contemplated in the petition. Now, please see the heading of the first page of my compilation alone, my lord. I'm not going to read each and every judgment, but my lord, may please see the first page of my compilation. A relief not prayed for cannot be granted. Supreme Court, Bharat Amritlal Kothari, para 29. Yes. I'm only citing the proposition and which is the judgment. That is a well settled. So he has not claimed a relief of stay on 19 or an anticipatory bail, etc. B, interim relief can only be in aid of the final relief. Again, very well settled. Therefore, the court, while passing a no coercive action order, never intended to put an embargo on section 19. Third, and this is important, my lord, if the court was considering a stay on the 19 power, akin to an interim anticipatory bail, even then the court would be required to consider the mandatory twin conditions under section 45. 45, please see, my lord, there are twin conditions laid down by the law that there are reasonable grounds for believing you're not guilty. That was not done by the court. Why was it not done? Because it was not concerned with an arrest under the PMLA. It was concerned with an arrest pursuant to execution of a warrant. Please see 45, my lord. 45, small Roman 2. Where the PP opposes the application, the court is satisfied. 45, small Roman 2. Where the PP opposes an application and the court is satisfied that there are reasonable grounds for believing he's not guilty of such offense and that he's not likely to commit any offense while on bail. But the order of 7th March does not satisfy this. So if my learned friend says that this order was intended to protect me from arrest, it does not answer the Section 45 twin conditions. There's a reason why, because this court never intended to grant him an interim anticipatory bail. Why? Because if it were to grant him, then please see page 60, my lord. The Supreme Court says in this compilation, a release from custody in any form.
Page
Please see
60.
page 60 of
One.
which is I'm reading the 3-judge bench judgment in Vijay Madan Lal, page 60, para 412.
60.
60, my lord.
Yes.
Para 412, my lord, may see.
Mm.
As a result, we have no hesitation in observing that in whatever form the relief is couched, please mark this expression, my lord, very broad expression, including the nature of proceeding, be it under 438 or for that matter by invoking the jurisdiction of the Constitutional Court, the underlying principles and rigors of 45 must come into play and without exception ought to be reckoned to uphold the objectives of the 2002 Act, which is a special legislation providing for stringent regulatory measures for combating the menace of money laundering. So if the court were to exercise a power of interim bail also to him, interim anticipatory bail, the twin conditions would have to be considered, which has not been done in the 7th March order or subsequent orders. Now, please see the 7th March order stood modified according to us. My lord, please see by the 21st March order. That, my lord, will find at page 62, where the court clarifies that there is a stay of NBW only. Page 65 at para 12, my lord. By a speaking order, the court only stays execution of the NBW.
65, which para you are relying?
Para 12, my lord. The court only stays, my lord, will see, non-bailable warrants shall remain stayed. So the impugned order is stayed and non-bailable warrants are stayed. Nothing on section 19. The reason, my lord, we are before this court and canvassing this is because we should not be perceived to be overreaching the court order in any form. This is a person, my lord, who is a fugitive. Multiple NBWs were issued. He was declared fugitive. On a technical ground, the order was stayed. There was a live lookout circular by the ED. He comes back from some illegal route back to India and the LOCs are not triggered. Lookout circulars are not triggered in the airport because my lord is aware if someone has gone out and comes back and a lookout circular is there, it will get triggered in the airport and he'll be detained. Those lookout circulars do not get triggered, my lord. He has come, our intelligence input says he has come from the Nepal route through illegal channels. He's now been arrested in multiple cases by the police and by the ED in another Hyderabad scam. I'm placing that order of remand also. We'll place it, my lord. He's been arrested in another Hyderabad scam. So today, we till date, we have not been able to interrogate him even once. My lord is aware, I don't.
He is otherwise inside.
He is inside in another case. But we want to take his custody under 19 for the simple reason, my lord, that he has not responded to summons. He has never joined investigations. He's never cooperated. So I am, my lord is aware, for the power of arrest, we don't need permission of court. We don't need a prior permission. We arrest and then we seek remand after 24 hours. Today, I am only seeking a one-line clarification that these interim orders were in the context of the petition filed by him and the relief prayed for, that is the stay of NBW alone.
That is writ large.
That is writ large. Fair enough. Then, my lord, may only take my application on record and my lord,
the
my lord,
subsequent order that you have shown,
yes,
order dated 21/3,
is explicit, but 7th March is causing some confusion where my lords have said no coercive. 7th March, my lord may see, so that 7th March may be clarified. That's the only request, my lord.
The subsequent order is later and there it is clarified only. The
It is
operation
clarified.
of the order shall remain stayed and non-bailable warrant of arrest issued also shall remain stayed. So only the NBW was issued, stayed.
The only problem is after the 21st, my lord may see, there is a subsequent order where my lords have said at page 68, my lord may see, interim order passed earlier in
Hmm.
criminal revision shall continue. Now, which of the interim orders passed earlier? The no coercive or both? Please see 68.
Yes. And this is in respect of same petition, right?
Same petition, same petition. So only that clarification that only interim order of 21st March has been extended. That can be clarified. And no prejudice is caused in that sense because my learned friend never challenged the section 19 power. No in anticipatory bail filed. So there will be no violation of court order.
Yes, Mr. Das, what I see is the no coercive action is of course is not.
My lord, today the matter has come up. My learned friend is making his prayer today for clarification of this order. So only what I am praying, nothing prejudice will be called. Already that person is already under arrest. One. Number two prayer has been made. I don't know whether because in page 14, kindly see page 14. See page 14. In page 14, if you see, copies of all the order passed in criminal revision petition are annexed here to fine. That's already there. Copies of all the orders or lordship copies of all the order passed in criminal appeal 1 of 2025 annex herewith and marks and annexure RA5. Only I have seen the copy of only the main order. There is no other orders which has been marked here as annexed in this petition. This is one. Number two, I don't know to what extent your lordship is holding if is up to page 86.
Yes.
Up to page 86.
Yes, up to page 86.
One. Second, if you see at page 14, all the orders, but when I find it is only one order has been annexed.
Criminal appeal.
Criminal appeal, if you see at page 69.
I am not seeking any relief in the criminal.
No, but when you are making a petition, all orders have been annexed. I have to point out.
Those are orders part of the court record. I'm not seeking any relief in criminal appeal.
No, please let me place it before the court. So copies of all the orders that is not before the court. So his petition, if he should only annex that order which is at page 69, not required. Why he has mentioned it? Secondly, my lord, before passing any order, what I pray that I will, my lord, opportunities should be given to file an objection in this case.
It is between the court and me, my lord. This application is between the court and me.
Cannot. I am sorry to say, this is I'll be prejudiced if any order is being passed. So if you have served a copy to me, I'll explain to the court what is the effect of 19. Let me file an objection to it. My lord, what I pray, my lord, I am asking a very short date. Maybe on Friday we are going to file it. This reply. And my lord, the matter can be taken up on 21st. Already is in custody. No prejudice.
He is in custody in a different case.
I'll explain. And they said the statement has not been recorded. They made an application. That's why I want to bring it by notice to the court. An application has been filed when this person was arrested in Faridabad. An application was filed. They sought for recording of the statement of this person in connection with Nagaland PS.
Yes,
so his statement was recorded. One day his statement was recorded on 6th. They wanted the statement to be recorded on 10th, 11th. That was rejected by the court. And the court has said you can record this statement in judicial custody on 6th. 6th, this statement was recorded. My learned friend is saying no statement was recorded. Please complete my argument. Let me complete my argument. I didn't disturb you. So what I pray before this court, I'll come with all the documents which we have and place it before the court. What is the effect of 19? What he wants a clarification of the order. What he wants, if you see the prayer he has sought for, kindly see to allow.
Mr. Concept, ED.
Yes.
He wants only a short date. He wants it on Friday. Today is the first day. He's junior copy. Let him go through.
Yes.
Then nothing is going to happen because he is already inside.
Very good.
Now what you want is that an arrest to be made, a shown arrest under section 19. That's what you want, and a statement to be recorded. So let the matter come on Friday, by Friday.
No, my lord, by Friday, my lord,
I will not.
Only one prayer is being made. No, I am sorry, Mr. Johe, one prayer is being made. 19, we are going to file this application. I have served a copy to my learned friend on 19. As one matter has been fixed on 21st, so let this matter be listed on 21st, that is Monday. Friday is very difficult, let it be listed on 21st. If it is not
My lord.
inconvenient to your lordship, and if it is not inconvenient to my learned friend, Mr. Zohaib, on 21st,
My lord,
that is Monday.
My lord may consider only two facts, then if my learned friend's request may be considered. Only two facts.
Right.
Only two things, my lord, may consider. Since 2022, 23, every summons that we issued to him, he did not appear. We got no opportunity to question him. This is a scam, my lord. This is not something that the ED is personally interested in. 903 crores siphoned off of poor people, poor investors by luring them that they will be given double the returns. These are hard. What are we seeking? We are only seeking to do our investigation fairly. Arrest is an inherent part of investigation. Large number of judgments are there. What my learned friend had challenged was only, my lord, with regard to an execution of NBW. Today, I am seeking a very, so that we are not in any manner seen to be overreaching. My lord, we could have gone ahead and arrested him, because what my lord is fallen from the bench is actually very apparent from the orders also. We need not have even come before, but we wanted to demonstrate our bona fide, our utmost respect for every order passed by the court. So even if two views are possible, we came before this court to seek a clarification. So, my lord, my request is of an very urgent nature, my lord. He is arrested in some other case. My learned friend says, what is the prejudice to you? My investigation has nothing to do with that case. He's arrested. That's another scam he's done in Hyderabad, where he's arrested, my lord. So I have to take his custody. His custodial interrogation is required. Where has he siphoned away all that money? Because we want to gather that money and pay the poor investors. 903 crores we want to recover from him, my lord.
Hear it
So,
finally. Whatever.
please hear it. Then therefore, please hear it finally. My lord may record that. Please hear it finally.
No problem, my lord. It can be heard. My lord, let my objection be filed on Friday, and Monday it can be heard. There is absolutely no problem, my lord. Monday it can be heard.
Fair enough. So then,
Yes.
Yes. Today, he wants to file an objection. Let him file
Yes.
it on Friday. Monday.
Yes.
And we will
Then-
consider your interim prayer clarifying the whatever orders you are praying for.
very well. Then my lord may take the application on board, my lord, and give him an opportunity. Issue notice on the application, my lord.
Heard Mr.
Deeply well. I'm Zohaib Hussain, my lord. I'm Zohaib Hussain, Special Counsel.
Special Counsel for the Enforcement Director and Mr. D. Das for the sole respondent.
Yes.
The instant interlocutory application is filed with mainly with two prayers. One, to allow the urgent hearing of the present application in view of the subsequent developments in the case pertaining to FIR number 24 of 24 registered by the Cyber Crime Police Station, Faridabad, and to clarify orders dated 7/3/25, 13/3/25, 21/3/25. There are so many orders. 28/25, 28/4/25, 26/5/25, and 23/6/25.
Essentially, it's only one order which says earlier orders extended. It's only one.
To clarify, to the extent that there appears no embargo on the exercise of power under Section 19 of the PMLA Act. Mr. Zohaib Hussain has placed the order dated dated on 7/3/2025, by which this honorable court had ordered that no coercive steps to be taken against the petitioner. That is the respondent herein. as well as the order dated 21/3/2025, by which this honorable court had stayed the impugned order dated 13/12/2024. That order is what? 13/12 order is what?
That is the order issuing NBW, which is the only order under challenge. So that's the final relief.
It seems in the order here, this court is speaking of two orders and the non-bailable warrant. Acha, you're right, operation of the impugned order dated 13/12 and the non-bailable warrant of arrest. Mr. Zohaib Hussain praised before this court that a clarification issued as to whether the no coercive action by the said order, before this, by the said order, or by a subsequent order dated 23/6/2025, the interim order passed in Criminal Revision 3 of 2025 was directed to continue till the next date. Mr. Zohaib Hussain praised before this court for a clarification as to which of the earlier order, that is order dated 7/3/2025 or 21/3/2025 was continued.
And in any event, these orders do not relate to section 19. That's my submission, my lord, may record.
Full stop. He further praised that these orders have no connection with the power that is vested on the department to arrest arrest under section 19 of the PMLA Act.
Much obliged, much obliged.
Issue notice to respondent, to the sole respondent. Oh, Mr. D. Das prays for a week's time to file an objection to the present interlocutory application. The prayer is allowed. He may file the objection by Friday. Full stop. List the matter on Monday. Give the date.
With an advance copy to us, my lord. Copy of the.
Only I prayed that my learned friend has given a compilation of the judgment.
I'll send it. I'll send it, Mr.
Please
Das.
send it because one of my juniors is there.
I'll send it through WhatsApp to you.
Okay. Thank you very much. Thank you.
And
Deep.
right that Mr.
We'll
Das.
serve the copy in advance to Zohaib. We'll serve the copy in advance to Zohaib.
To
Deep
that,
obliged.
to
Yes.
that, the what objection that I have said, Mr. Das will serve a copy upon the petitioner.
Deeply obliged. Deep.
I'm deeply obliged, my lord.
I'm so grateful.
Yes, Mr. Das.
For admission, item number 2.
Keep this copy with the file. Item number 2.
May it please, your lordship. Contempt matter. What has happened here, if your lordship will see the last order. Otherwise, everything, the order judgment is clear. They are supposed to make a payment of
Yes.
around 4.70 lakhs.
They
The
have not paid.
compliance is not coming from the deputy commissioner of the concerned district. So in the last order, the honorable court had observed that it expected that the amount be paid by the next date and the compliance report is to be submitted. Now, today morning, they have submitted an application or in fact a compliance affidavit. Now, the compliance affidavit, not know it is on record or not.
Yes.
Now, in the compliance affidavit,
Let
at
it be
per-
put on record then.
I am just placing on.
Lordship,
Yes.
this morning I'm for respondent number
Five.
5, Lordship. And this morning I have filed our compliance affidavits stating that a substantial amount has been paid to the
Yes, I want to
affected
submit
landowners
something
to
on
the
that aspect. How they are misleading this honorable court. Just
No,
let me-
no.
Let me complete. Let me
Achha,
complete my
okay.
stand.
Hmm.
Now, what he has said, paragraph 4, he says, accordingly, in pursuance to the circular so and so, substantial amount for damage compensation has been paid to the affected landowners and beneficiaries. Now, if I may just place this list of.
Substantial payment will not suffice.
No,
Lordship, in
no,
fact,
I
a circular has been issued to
I will
all the
show- I
affected
will show
landowners and the
whether it is
beneficiaries.
substantial or not. Lordship will see, this is the list of the assessment seat, which is a part of the PIL where the judgment was passed. And Lordship will see the figure at the first page, 4 crores 70 lakhs. So it was based on this assessment, the amount was directed to be released. And the last page, if a Lordship will come, the last page, total number of beneficiaries is 177.
Where do I get?
The last page,
177.
Mega Kezo. So 177 beneficiaries amounting to 4 crores 70. Now paragraph 4, they say substantial compliance. Now let me see the substantial compliance. They have given a list where they have made the payments. The list ends at serial number 18. Of 177, they end at 18 and they have the audacity to come before the Honorable Court and say substantial compliance in a contempt matter where the compliance has not been happening from February 2024.
See.
So Lordship will kindly take this with some concern and ask the Deputy Commissioner to be present on the next date.
No, Lordship. if
How
I'm-
could they
I'm-
restrict the
I'm
Honorable
allowed
Court
to
by
make my
saying that using the word substantial?
I'm
reading
allowed
from
to
their
make my
affidavit.
submission. If I'm allowed.
I'm reading from their affidavit, 18 beneficiaries been paid and they use the word substantial compliance. Let them explain that.
Without even specifying what amount was paid.
Lordship,
Have they specified what amount they have
This,
paid?
no, they have not specified. They have given a list of people who have received. I
And
see
with
the list
amount-
ending at,
With the amount.
yeah, with this amount, but 177. 18 and they say substantial. How are they playing the court like this, Lordship?
Lordship, I'll.
How could they use a word like this? Yeah, I'm over. Now you can submit.
Okay.
Mm.
Lordship, circular has been issued to all the affected landowners and beneficiaries, informing them to appear before the Deputy Commissioner for disbursement of their compensation amount. And this has been informed to all the beneficiaries and to all the affected landowners. Lordship, here is a case where a compensation amount has to be paid to all the affected landowners, no doubt. But now the issue comes, it cannot be given it to the Tom, Dick, and Harry. They have to approach their competent authority and to submit their so-called their account number as bank account number, as
Bank
well
account.
as they have not approached before the administration, before the authority. And the administration themselves cannot go to house and say that your compensation has to pay. So I'll give you the compensation on that itself. They cannot do that. They have to, since they have been informed as per the circular that was issued by the administration.
Point, what do you say?
Lordship.
They
So
have not-
when they are not before the authority, how can we say that that has not been
Have you
complied?
mentioned in your affidavit?
Lordship, that I mentioned, Lordship, we have said that substantial amount has
No,
been
let me see
paid
that paragraph.
as per the circular, Lordship. Circular has been informed. We have given the circular
Acha,
to
let your affidavit be placed on record.
Lordship.
Okay.
Lordship.
I will see whether those pleadings are there.
Lordship.
it's not.
Otherwise, of course, they have to come to you and take the amount. That
this
is
is-
the point.
Lordship, that's what we are saying, Lordship. We are saying that circular has been issued. Lordship, may
But
kindly.
see, from that, since 24, you have not paid. That is.
No,
raises doubts.
Lordship, there was no deliberation on the part of the authority, Lordship. What happened was the check was issued earlier, but it was bounced, Lordship. And thereafter, the authority approached the
Check
government,
bounced.
check bounced. And later on again, a
Having
new check
private
was
party,
issued.
We can understand, check bounced.
New check was issued. Thereafter, a circular was issued informing all the affected landowners as well as the beneficiary to approach the competent authority
How did you inform the people?
through circular, Lordship. Through circular.
Published in some particular place? Or
Lordship.
newspaper?
Circular was issued, and in fact, in the circular also, it is clearly mentioned a copy to all the village council chairman, Chedama, Satakama for information and to present for identification of the landowners.
When was that circular?
That circular was 11 June 2025. Lordship. And it is also mentioned that in the office shall be paid to the concerned landowner beneficiary in the office of the Deputy Commissioner Kohima starting from 18 June 2025, 11 a.m. onward. Therefore, all the concerned are informed to come in person for collection of the same, Lordship.
Have to know.
No.
Lordship, in fact, they are
No.
well aware, Lordship. Because of that, some of them has approached and they have already received the compensation amount. And Lordship, since that is not part of the report, if that
Acha, let this be placed on record.
Lordship,
Take it
This
up
is
Friday.
Lordship.
very unfortunate Very
No, no,
unfortunate.
no, no.
No, let me just, this is very unfortunate. First of all, this statement is not supported by his pleadings. Secondly, this statement that we have not approached is completely incorrect. Persons have fought for this money by filing a PIL, subsequently got an order. Now they are fighting this contempt petition, engage the counsellor from Gauhati who is here before lawsuits to argue, and they will not go to the Deputy Commissioner's office to collect the money. It is very unfortunate. These kind of misleading statements are made before this Honorable Court. They are there every day, they are going there, and the Deputy Commissioner is asking them this and that and returning it. And this is for vested interest, if I may say so. Money is to be distributed, this is for vested interest, which is what is happening now.
Lordship,
Lordship will therefore categorically pass strict orders.
Lordship is.
We will appear on a particular
Lordship
date,
will-
let them make the payments. On the next date, report will be submitted for 100% compliance.
Lordship, in fact, we are ready, we are complying with the course order, Lordship.
They're on record.
Lordship,
And
Lordship.
Only 5
You-
paragraphs. I have seen the paragraphs. Only 5 paragraphs. Nothing is there. Lordship. Lordship may
There
produce
is
it.
a way it should be praised, or you
I
step back,
understand.
or you can appear online also. And I'll take it on Wednesday.
Lordship,
Friday.
Lordship, Lordship.
I'll
Anytime,
see
anytime.
what are the pleadings and
Lordship, Lordship,
then
definitely.
after that I'll pass orders.
Lordship. Since that is not part of record, I cannot go into that, or else I could have.
Ah.
Just Friday.
Any day.
On 18th.
You can appear through online, no issue.
Yes, Lordship.
I'll not trouble you coming so far.
Lordship,
from-
Lordship.
What's
It is available.
Mr. A. Sharma for the petitioner. For the petitioners. For the, yes, for the petitioners. As well as Mr. So-and-so. For respondent number 5 and other respondent 1 to 4.
Number 3.
Acha, acha.
I am ready for respondent number 1.
Consent
one.
will also only 5 now.
Yes,
Non-compliant only.
only with 5.
Yes.
So it is stated at the bar that an affidavit was filed by respondent number 5 today morning.
Got
And as such, it is not on record. The same may be placed on record by the registry on the next date. And matter to be taken up on Wednesday or Friday, whatever.
I will on 17th then. also.
Anytime.
17th.
17,
Thursday.
okay, Thursday.
On 17th. also.
List the matter on Thursday.
For appropriate orders. Lordship.
For appropriate. So
Oblige, Lordship.
you can take back this,
It can be a part of the record. I have a copy.
let it be here.
Yes, because that is the list of beneficiaries. Oblige, Your Lordship.
For admission, item number 3.
I think the one party took time for filing a written objection.
Yes, Lordship.
Was it filed?
Respondent number 2
Mm,
is yet to file it.
Not filed.
Not filed.
Yes, I've not filed, my lord.
Respondent number 2. You're
I'm
appearing
for
to
number
respondent
2. Yes, my lord.
What objection to this criminal petition?
A preliminary objection, my lord.
What is this petition? For
Lordship.
quashing?
Yes, Lordship. Quashing the criminal proceedings pending before JMFCB Mahapur.
Normally, no objection is required. He is praying for quashing of the criminal proceeding. If at all he has a case, it can be done. But then you have already taken time. Will you file it in a day or 2?
I paid for 3 weeks, my lord.
3 weeks. What is the requirement? Otherwise, see, it's only for. You have, yes, so that criminal proceeding only we have to see the FIR, the charge sheet as well as so and so. File it by this week. Why keep it pending for so long? This was filed when? And perhaps the stay is operating.
Yes, Lordship.
So it is stayed from 24. 5th of August 24. Almost a year now.
My lord, I'm
File it by this week. We'll take it up next week.
okay, my lord.
Okay, because already you had taken time. So as prayed for by Mr. So-and-so,
Lordship, there's an interim. Interim may be extended.
not as prayed for, Mr. So-and-so appearing for respondent number 2, further prays for a week's time to file the affidavit in opposition to the criminal petition. Prayer is allowed. The affidavit may be filed. Within Friday, you file it and we'll take it up on Monday.
My lord, actually, I'm appearing on behalf of Kama Alin Romai, who's the leading counsel in this matter.
Try to file it by Friday.
State have also not filed, my lord.
Not filing. Here we are pro forma.
Also,
Yeah.
You have only taken time to file. Let the affidavit be filed by Friday by giving copies to the petitioner. List it on Monday. Okay.
Okay.
Much obliged. For admission, item number 4.
Counsel? Huh? Oh, you,
Yes,
okay.
my lord.
So he was supposed to surrender by
I
today.
file IA, my lord, yes. The accused have approached before the trial court. They have already reached the trial court. So, in the meantime, I file IA.
Okay.
Since
So he
I-
surrendered.
Yes, my lord.
So I is for what?
I'm praying to regularize my interim bail order since still I'm under medication. And the concerned doctor who operated on me have asked me, have directed me to appear on 19 July for review. A keyhole surgery was done on
Now where are the
30 May.
reports?
My lord,
Today only he has, where is the public prosecutor? Who appears
Uh,
for? You're,
Lord Senior Vijamumi, he was appearing. He appeared before in item 2. Maybe he have other
so
matters.
call him.
Okay.
Now where are his medical papers?
Yes, my lord, on page 32.
Please call him or her, whoever, additional public prosecutor, anybody can appear.
My lord, one of my colleagues has gone to call him. My lord.
Okay, after some time, Mr. After some time,
Yes,
after
my
he
lord, no
appears.
problem, my lord.
Okay.
I'll do that.
After some time.
He's here.
Oh, he's here, come. So he has surrendered today
Lordship,
in view of the High Court's order.
Lordship.
Now that he wants further bail so that he can go through the treatment operation, he is saying. What do you have to say? Do you have the papers?
No, Lordship, since they have filed this morning, Lordship, I don't have any instruction, Lordship.
Since you have also surrendered today, I'll take up the matter day after tomorrow.
Lordship.
When is your operation fixed?
Appointment for review was fixed on 19th of July.
Oh, yes.
19th of
What
July.
review? That
Yes.
is a review. Today is what date?
Today is
14th.
So I'll take it
Lodge-
up. He
lodge.
has surrendered today. Give him papers. We will examine
Lordship,
and let the matter come up on Thursday or Friday.
Lordship.
Okay.
My lord,
As-
the matter can come up
Huh?
after one day, tomorrow, or since he's a senior citizen, and going back to jail will be very difficult for him since he's under medication.
They will take care. Jail authorities are bound to take care. Let him, he has surrendered today. So within a day or two, let him go through, or Thursday
Lodge.
you can take it. up.
Thursday, 17th, 117.
So heard Mr. Swenson and learned your APP,
PP,
PP.
Lodge.
Yeah, I have heard Mr. Swenson. Your PP, your name?
Vijmomi.
B. Jimomi.
Vijmomi.
Okay, the learned public prosecutor for the state, as ordered by the order dated
2 May 25.
2nd of May 2025. Wherein it was directed that the accused shall surrender on 14/7/2025. The accused, it is stated by so and so that the accused has surrendered in the morning of 14/7/2025 and is now in incarceration. However, the counsel appearing for the petitioner submits that the accused person is still undergoing treatment and that he was directed to appear before the, where did I get this review thing? Was directed to
On page 36.
Huh.
On 36 page
the
36.
medical, this is what? Medical Care and Research Center.
Yes, my lord.
before so and so for a review of his health on 19/7/2025. The instant IA is filed today morning. As such, the learned PP prays that he may be given some time to go through the same. Prayer is allowed. You have given him copy?
Yes, my lord.
Prayer is allowed. List the matter on Thursday next.
Yes, my lord, I also apprised his honorable court that the co-accused, she was released on bail on ground of arrest, since there was no
There
ground
is
of
a
arrest.
co-accused.
Yeah.
He's, oh, acha.
The co-accused is already released by the trial court on ground of arrest.
On non-service of grounds of
Yeah,
arrest.
yes, yeah.
No,
The co-accused.
This is Mr. Gauhati, right? What is
Yes, my lord, I'm only apprising this honorable court that there's one co-accused, and the co-accused was released on bail on ground of arrest, as there was no ground of arrest in the arrest memo.
Here
So-
also no grounds.
Yes, no ground. So, my lord,
Acha,
if the honorable court on that line, if the honorable court may also release.
let him go through this and then we will
Lordship.
consider it on Thursday.
Lordship.
Okay. List the matter on Thursday.
For admission, item number 5.
May I please lordship? My lord, in the last occasion, state was directed to produce the CD.
Case diary is here.
Yes, madam.
Okay, let it be with you. I'll ask whatever is.
Lordship.
You are on interim. You are on interim.
Yes, on 27/6/2024, 25,
Yes.
anticipatory bail was granted. And just on the next day, 28/6/2025, I have reported to the PS, the concerned PS at 10:30 PM. I was there interrogating for till 4:30. On,
Entire night.
no, during daytime.
During
4:30 PM. 10:30 to 4:30 PM. And thereafter again on 30th June. From 2:30 to 4:30. I have given the statement. And again on 2nd July 2025 at 3:25 PM. I reported and then given the statement till 4:25. And on,
Second time your statement was recorded.
yes, and then on 9/7/2025. The CGM has passed an order. I have appeared before that. And then I have given the consent for voice sample,
Acha, voice sample.
voice sample. And then I'm waiting for that.
Hmm.
As and when they call, I will go and then give that.
So he is in a way cooperating with the investigation.
My lord, your lordship, may kindly see the city and
The offense is under what? Arms Act.
No, Lordship. Under section 61, clause 2B, 199, 249, 255, 256, 260,
Where I'm not.
and section 5 of Official Secrets Act 1923.
You are appearing for Katovi Jimomi.
Yes.
There are two accused person. No, maybe the other accused is
Yes.
someone else. Acha. Now what are the offense you said? Where is the FIR? There is no FIR. Registration.
Page 15.
Yes. These new sections I'm yet to get acquainted with.
Yes, yes. For all of us, Lord.
Yes. 61 is what?
61 clause 2, subclause 2 is criminal conspiracy, my lord.
199?
199 is public servant is obeying direction under law.
Okay.
And 249 is harboring offender. And 255 is public servant disobeying direction of law. And 256 is public servant framing incorrect records. And
Furnishing incorrect records.
yes,
You are a
I
public
mean-
servant, Mr. Jamil.
yes, my lord.
You are a public servant.
Yes, I'm
Okay.
serving as an assistant sub-inspector,
Assistant,
assistant sub-inspector of. police.
ASI,
Yes, ASI.
and Official Secret Act also. So let me go through the FIR once. It is at page 19.
Page 15 of the petition. This is arising out of a factional clash of two
Page
factions.
It's proper, I think. Here, I think page number is 15
Yes, 15.
or 15. 5 is not properly written. Okay. You were found divulging all important information. Of course, that's an allegation.
That is the allegation.
Yes, pertaining to the investigation as well as operational preparedness to the target. So as to aid and assist the main accused to evade arrest and resultantly the main accused and the others continue to remain at large. But otherwise, the allegations are very serious. The actions of the aforementioned police officer who is apparently investigating, he is also the IO.
Yes, because there was no one to
Hmm.
accept this assignment. And actually, as per the procedure, IO should be above SI,
What should
above
be?
sub-inspector,
Now, what should be above? What do you say?
sub-inspector of police.
The
But then-
investigation should have been done by.
Yes,
a high-
initially it was entrusted to one SI. He declined because nobody wants to involve in this kind of cases. So he was assigned this as the IO. He refused actually, initially. But then since the authority is trusting him, then he cannot defy that. So he has to reluctantly accept to be the IO. So in the process of investigation and then extracting any information, there are different forms of getting the information from the accused. IO may interrogate in different, by applying different methods. So some communication was there. But everything has been put on over the petitioner. Because what happened?
You are given 35(3) notice. Right, to appear.
Yes.
Oh, acha, acha. You appeared and everything happened. But then this is not a case for bail. What are the
So,
materials? in
my
this
lord,
city?
your lordship may kindly see the CD, my lord. Page number 1, that is the FIR copy. I have lined the important points, my lord. Your lordship may kindly see the Bharat 3. That is the
This
series,
page?
yes. That is the allegation, my lord.
During the tech, this is the
Yes.
FIR thing.
And my lord, in the page number 3, page number 3, that is the complainant statement. And in the, your lordship may kindly see page number 6. That is the call details record. Page number 6. May I read you, my lord? I now received the CDR of mobile number so-and-so, and as per the call detail records received from the competent authority of mobile number so-and-so, accused and number series so-and-so, it is ascertained that the two above mentioned mobile number had been in contact 4 times.
So this,
So-
this mobile, there are 2 mobile numbers.
Yes, that
So one belongs to the accused.
one belonged to the accused and the one belonged to the suspect's wife, the target wife.
Targets, right?
Yes, yes. So they were on 4 occasions they were on contact. And your lordship may kindly see the page number 11. There is the re-examination of accused
Page
statement.
number 10 is his statement.
Yes, accused statement. And that page number 11 is accused restatement, re-examination, my lord.
Okay.
And in that also in para 4, he has admitted that he was in contact with the lady, my lord. And they have a discussion on, your lordship, may kindly allow me to read this para.
Which one?
Page
We
para,
have marked it.
para 1, 2, 3, para 3, starting from para 2, 3. On 10/6/25 at around 11:12, I went to Mrs. Cavino resident to record a statement, but she was not found.
That
And-
Kavino is the lady.
Yes, lady.
Wife of.
Yes, target. And as such, I left my personal mobile number with one of their helper who was present at that time. The accused left his phone number to the helper. And around 16, I received a call from a non-male person who inquired about my prior visit to the resident for statement recording and asked me to attend the following day. On 11/6/25, at around 11, I went again to record the statement of Mrs. Gavino, during which I collected her mobile number, which she provided. But it was found inactive, whereupon I requested and received an alternate contact number from her. I did not share the alternate contact number of Mrs. So-and-so to any of my superior officers, which I admit as my negligence. And I also felt that since she was a civilian, it wasn't important to submit her alternate mobile number. I was in contact with her on 3 or 4 occasions. And as far as I am concerned, I did not divulge any confidential information pertaining to the case. On one occasion, I contacted her to further develop her statement, and during this interaction, she posed a query regarding the traceability of switch-off mobile numbers, and I offer my opinion with no ill intent that it might not be possible. She also questioned about the increased police frisking, and I explained that it was part of our routine day. She also inquired if I had any knowledge regarding the investigation agency tracking her husband's current location, to which I replied that I had no information. Upon her inquiry regarding the status of the case, I informed her that a charge sheet would be filed upon apprehension of the accused, otherwise a final report would be filed. That is the discussion between the target wife and the accused. The lordship kindly see the last page number
14.
Page number 14. That is the cross-examination to the accused.
Cross-examination of the accused by the police.
Yes, my lord. To the statement, yes. On 3 occasions, he was examined, my lord. And cross-examined, and so during re-examination, he stated that a lady constable accompanied him while he recorded Ms. So-and-so's statement. He further mentioned that after the recording, as they were preparing to leave the room, Mrs. Cavino approached him and provided her active contact number, asking him to save it for future or work-related purpose. It is also learned that he has been taking up many cases in his service after being promoted to ASI. Note: during further recording of ASI so-and-so statement, he was also made aware that evidence has been collected against him that clearly disclosed he had indeed shared secret and crucial information with so-and-so over the course of the conversation on their mobile phone in case number 25 of the Mumbai PS. He was also made aware that this irrefutable evidence was obtained through a legal surveillance authorized by the competent authority. However, the arrested accused person, ASI so-and-so, stated that he had not shared any secret or sensitive information with so-and-so, nor does he remember sharing such information, and that he stand by with what he had already stated earlier. He further continued to deny all charges that have been leveled against him in the FIR by the complainant. So, my lord, from the records from the CD, it is clear that there is a conversation between the target's wife and the accused. So, my lord, there is a clear violations of section
That
5 of the.
statement of the person who accompanied is also there, right? Who accompanied Katovi, the accused.
Yes,
And this is at page 17, I think. I was
Yes.
called by accompanying him taking statement of Mrs. Kavino.
Yes.
When recording.
So my lord, here the accused is also admitting that they have a
Achha, they
conversation.
spoke in some other language,
Yes.
but I did heard them mention a contact number and I could not recall much, but one and detailed a mobile number on there. As far as I'm concerned, that was the only time when they mentioned about a contact number which was important. Setting them.
So my humble submission is, my lord, the interim order granted on 27/6 may be vacated and anticipatory bail should not be granted to the accused. Because the prima facie appears in the case there is an involvement. And it is,
One thing is very surprising, if the police, some police personnel is ordered to investigate a particular case, how can he deny?
yes, ma'am.
One denied, he left. He also denied, but then he was forced to investigate.
Yes.
Now he is investigating. And then there are again conversations with the wife exchanging numbers.
Yes.
Those allegations are there. We are only with the allegations now.
Lordship, that is their story, but that is one side of the story. Now, on 24th May 2025, we are dealing with the issue of factional clash. So the accused is a person who belong to an insurgent group also.
Who belongs to?
Insurgent group, insurgent,
Insurgent
NSCN-K and Congo. There are two factions. This problem arising out of that, there was factional clash. So there was nobody to take up the case. So one was entrusted, but he declined, and ultimately he was asked to do it. So he had to reluctantly accept that. On 24th, the case was entrusted to him. On 25th May, a team of police led by the officer in charge of the concern, that is Tipupar police station, went to the house of the accused. Now, on that day, there was resistance. So since it is a civilian area, so the police party, in order to avoid any confrontation, because there will be exchange of fire ultimately, so casualty will be inflicted on the civilian areas. Therefore, in order to avoid that, they have not entered to the house of the accused, and they retracted and they went back. Next day, a team led by the high police officers, led by the Deputy Commissioner of Police, that is on 26. And they went to the place of occurrence, but on that day, nobody was found. That may have agitated the higher officers, thinking that, oh, the petitioner at the IO may have passed on some information to the accused. That is their apprehension. And on that day, since they could not find anyone in the house, so all the blames are coming towards the petitioner. That is one situation, Lordship. And on 10th of June, the petitioner went to the house of the accused to take his statement, but he was not there. So my learned friend has mentioned about the exchange of mobile with his wife and all that. And then on 11th of June, that is the next day, he went to the house of the accused and recorded his statement.
The petitioner went to the house.
Yes, that is on 11th. And then on 13th June 2025, he was asked to submit the status report. That is on 13th of June. Next day, he has submitted the status report. Incidentally, on that day, his transfer order was also issued, transferring him to Shamatur. That is in the far-flung area. So he's already transferred out on 14th of June. And then on 23rd June, when he was traveling to Shamatur to take the charge, to submit his training report, and that day he was summoned to the police station to record his statement, but he did not go. That is how the order was passed. And then anticipatory bail application was filed before the session judge. That was rejected. That's how the present application has been filed. And the next day, that is on 27, and this honorable court was gracious enough to grant the anticipatory bail on 27. And thereafter, from the next day, from 28, the petitioner is cooperating with the investigation. So whatever may be the case, whenever they call, I go and attend. I'm a government servant. I have served the government for the last 31 years without any blemish record. And now I have been transferred out as a punishment.
Where is the interim order?
That is on 27.
Yes. Yes, come on. See the allegations that you
So-
have shown from his diary. Exchanging of numbers with the wife is there. But then there are no further allegation that any secret information or whatever is being divulged or is being they spoke about something which should not have been there. Those things are not there. Even the person who accompanied, she said that they spoke in some Sumi language.
Yes, my lord.
But then I could make out only about exchanging numbers, nothing beyond that. So any conversation between them about the case or something which should not have been spoken amongst them, those things are not there. Further, he is cooperating. Interim order is there. He will cooperate and you can always come for cancellation.
My lord, since
Lordship,
You are the APP,
PP, my lord.
PP. Oh,
Yes, my lord.
yes, I get
My lord,
confused.
since there is a in the city, it is clear that in the call detail records. So
Those,
yes,
because
also
he's
person
the
on that.
he is the IO. He has to call the witnesses. Even if those are defense or prosecution witness, whatever. He is investigating. He might have some questions to be put to the wife.
So,
of
my
the
lord,
accused.
my humble submission is, my lord, interim order should not be granted, and my lord, and this anticipated bail should not be granted, and the sufficient time will be given to the investigation agency to investigate to get the matter as per the law, my lord.
He went.
My lord,
yes.
Whenever he was called, he was again called for the second time. Re-examination and all those are also done. The person who accompanied also did not say. Right. Let him be on bail. Bail, case will continue. And he is cooperating. Had he not come, the matter would have been different.
no, my lord, interim bail should not be granted, my lord. That is my humble submission.
If the petitioner failed to cooperate with the investigation, they have every right to approach this honorable court with an application for
Yeah.
cancellation also.
Where heard Mr. C. Jamil.
T. Jamir,
C.T. Jamil.
assisted
Learned
by
Senior Counsel.
I.M. Chen,
Yes.
assisted by I.M. Chen.
Yes, learned senior counsel for the petitioner, assisted by so and so. And Mr. So and so.
E.T. Papum.
Yes, Papum, the public prosecutor for the state of Nagaland. This is this is a anticipatory bail this is a bail application. Yes.
Anticipated.
Anticipatory
Yes,
bail
this
application
is a B, right?
under
This is an
four
anticipatory
eighty-two,
bail application filed under section
482.
482, yes. File under section 482 of the BNSS 2023 for grant of anticipatory bail to the petitioner in the event of arrest in connection with police station case
Tipu
number.
Par,
What
please.
police station?
Tipu
Diffufar.
Par,
Diffufar police station case number 40 of 2025 under section 61 subsection 2 B, small b within bracket /199 /249 within bracket C /255 /256 /260 of BNSS read with what is this section 5?
section 5
Secret
Official
Act.
Secrets
Oh,
Act
yes. That was not written in the
1923.
cause title. Yes, section 5 of Official Secret Act 1923. The prosecution case, as is revealed from the first information report, first information dated 17/6/2025, is that in a case where a lawful surveillance of a mobile number. Wait. The same was approved by so and so. That case was different, the where there was a fighting between two factions, right?
Yes.
In that case, lawful surveillance of a mobile number was
Yes,
done.
yes.
Okay, what did I say? Is that a proposal for lawful surveillance of a mobile number? Sit, Mr. Talib, please sit. Yes. In a proposal for lawful surveillance of a mobile number in connection with a case, in connection with a DPR police station case number 0033/ of 2025 was initiated. And during the said surveillance, the accused person in the said case was found to be in contact with the petitioner through his mobile phone. It was also, full stop. It was also alleged in the FIR that the petitioner was found divulging important information pertaining to the investigation of the aforesaid case aforesaid case, so as to assist the main accused to evade arrest. Full stop. The petitioner was as such held responsible for criminal conspiracy as well as other offenses amounting to cognizable criminal cases. Was allegedly found responsible, you say that, allegedly. The police, on receipt of the said FIR, registered the case as Difufar Police Station case number 0040 of 2025. The Mr. Tali, Mr. C.T. Zamir, the learned senior counsel, submits before this court that the said allegations is not backed by any evidence on record, BACK at ED, evidence on record. Full stop. He had placed the order dated 27/6/2025, by which this honorable court had released a petitioner on interim bail. And he further submits that pursuant to the said interim bail, the petitioner had appeared before the police officer and has given his statements on twenty-seven, 6, 2025, as well as on
Lordship, 27 is the date of the bill and 28/6/2025,
mm,
30/6/2025, and 2/7/2025.
you
3
have given
days.
three
Yes,
states.
3 days.
All these dates. You have recorded, written those dates, huh? He has appeared before and has given his statement on so and so, so and so.
And then I have appeared before the CGM on 9/7/2025, the
He
order
also
of which I have
states that
placed.
he appeared before the CJM on
9/7/2025.
9/7/2025 on a prayer made by the investigating officer for collection of voice samples. He has given his consent,
Yes.
to which he had given his consent. As such, it is prayed that the petitioner may be released on bail. Full stop. The learned PP for the state of Mizoram places. On the other hand, learned PP for the state of Nagaland submits that the offense involved in the instant case is serious and that there are enough evidence which shows the petitioner being in touch with the wife of the main accused person in the other case. He had placed the case diary and had shown the stipulations made in the same, wherein it demonstrates that the petitioner had called the wife of the main accused 4 numbers of times, which is reflected in the call data records received by the police, the IO, the police or the IO. He had also placed the statements of the accused person, wherein he had admitted of calling the wife of the wife of the accused person in the other case. Full stop para. The heard learned counsels for the petitioner as well as the state counsel. It is noticed in the case diary that although 4 numbers of calls were made, between the petitioner as well as the wife of the accused person. However, in the statement of the accused person, it is seen that the petitioner went to the residence of the wife of the accused person and having not found her in her place, he left his mobile number and that he got a call from her and that and cut that line, and that after getting a call from her residence, he went and recorded her statement. He also stated that he had not divulged any confidential information pertaining to the case to her. It is also not noticed in the case diary about any information being divulged to the wife of the accused person. The other police officer, he is also a police officer. The other one,
My lord, here only the accused is the police officer, my lord.
Acha, this Rose Cut, oh, he's a government servant. No, he is also currently attached to CP Dimapur and posted
Yes,
as
yes, yes.
telephone duty. I was called by Iman to accompany. What did I write? What did I say? No, cut that. Is he a police officer? It's not written.
Which
The
one?
other witness who accompanied the petitioner to the
Lady
house.
constable, lady constable.
Lady constable, yes. The lady constable, don't write the other witness. The lady constable who accompanied the petitioner to the house of the wife of the accused person had also not stated of any secret information being divulged by the petitioner to the wife of the accused person. She however stated that the parties, that is the petitioner and the wife of the accused person, spoke in Sumi, but then, which she could not understand, and that she only could make out the exchange of phone numbers between them. It is therefore noticed that pursuant to the interim order, the petitioner was called by the police officer or by the IO, by the investigating officer, which he complied with, and he went on 27th, right? 28th of June 2025 and gave his statement. He was further called
On 36/2025.
on 36. No, this statement was recorded on Katovi's statement was recorded on 27 itself. 27.
Okay.
27 at 17 hours. No, you cut that 28, you write 27. Thereafter, he was again called. I said, no? Yes. And then he again appeared on 28/6/2025, on which date he was re-examined. Further, he was called on 30th June, to which he complied and he was again examined.
Yes. Next is on 2/7/2025. 2/7/2025.
27 is what day? He again went. 2-7, he was again examined.
Yes.
2-7. It is not marked. Again on 2-7-2025, the petitioner was called and he was further examined. Thereafter on 9-7-2025, he was called by the CJM Dimapur, Nagaland. To which he appeared and he gave consent for his voice sample, for collection of his voice sample. It is therefore noticed that the petitioner had not violated any of the order of the investigating officer, and he cooperated with the investigation as and when called for. He had also given the consent for his collection of his voice sample. As such, this court we have written, he is a police officer. I'll include somewhere. He is a police personnel. And then you write, then this court releases the petitioner on anticipatory bail upon furnishing of a bond of rupees 30,000 with 2 local sureties, one being a local resident,
Yes.
one being a local resident of the state of Nagaland,
Yes.
to the satisfaction of the arresting authority. The anticipatory bail order is, however, subject to the following conditions. 1, he should cooperate with the investigation and should appear before the IO as and when called for. Number 2, he shall not tamper with the evidence or influence any of the witnesses connected with the instant case. He will not leave the jurisdiction of the investigating agency. That is what? Which place?
Dimapur, that is Tipupar PS.
Difufar. Will not, local jurisdiction of Difufar police station.
Yes, my lord.
Difufar police station without the leave of the investigating officer. Okay.
My lord, if your lordship agree, your lordship may kindly record my statement, one sentence, because I'm objecting the granting of anticipatory bail and
In his thing
And-
where I have said he has placed those,
yes,
case diary, as such, he objects to the grant of bail
and vacate the interim granted on
and to
27.
vacate the interim order.
And gives sufficient time to the investigation agency to investigate the matter as per the law.
They will do.
That
and they-
the statement may be recorded, my lord.
Your objection is there, so in so many terms. And then interim order is also vacated. We need to vacate that interim order. Oh, no. Yes, he is released on bail. Okay.
Rather, it should be made absolute.
Oh, yes. Yes, the interim order is made absolute. The petition is disposed of.
Much obliged.
For admission, item numbers 6 and 7.
There is a delay, no?
Lordship.
In filing
60
the bill.
days. is the
You have for
bring-
the insurance.
I'm for the insurance. Yeah.
Why you are not paying? You don't want to pay money?
Lordship. Grounds,
You will file objection or what to the?
I've been
Lord,
informed.
I'm for respondent number 6,
Acha, acha.
and I'm only the insurance broker. Actually, I have nothing to do with in
Okay.
the instant case, Your Honor.
Today it has come up for the first time.
Lordship, after the motion, Lordship, second time. Lordship,
Lordship,
Uh-huh.
appearing on behalf of Mr. Im Tiwapang, the counsel for respondent number 1 to 4. Those are the claimants.
1 to 4,
Yes.
1 to 5, otherwise 1 to 5, I think.
Yeah, 1 to 5.
1 to
5.
4.
And you are for 6.
6, Your my lord.
What, we want to file, you want to file objection? You're the
Yes,
claimants.
Lordship. Yes, Lordship.
You are for the claimants, all the five.
Yes, Lordship.
You want to file objection to the IA or you don't want to?
We want to file, we will be filing. Lordship,
Let me
however,
file objection then.
Lordship,
Delay is for
60 days.
60 days. So, you are seriously objecting or you will go with the merits or you will contest?
I was
Lordship, lead.
instructed to say that we'll be needing time to file the objection.
Okay. Heard Mr. So-and-so for the insurance company. And Ms. So-and-so for respondent number 1 to 5. And Mr. For respondent number 6. The Miss So-and-so appearing for, what is her name?
Asanla Longkumar.
As Longkumar.
Asanla.
Asanla Longkumar.
Yes.
Asanla Longkumar appearing for respondent number 1 to 5, praised for some time to file an objection to the interlocutory application. File for condonation of a delay, file for condoning the delay of 60 days in preferring the
Negative.
MSC appeal number 6 of 2025. Prayer is allowed. List the matter after 2 weeks.
Bless me.
For orders, item number 8.
This is a state's application. What happened? Where is the public prosecutor? Yes, they are there.
Lordship,
This is an application filed by you
Lordship.
for what?
Uh,
Item number what? This is item number
8.
8. Oh, you have come against discharge order.
Lordship, against the discharge order, Lordship.
So I think,
Yeah.
I don't, service is not complete.
Service is not complete, Lordship.
There
In
is
fact,
only one respondent.
one respondent, Lordship. Thank you.
Let me see if nobody appears, we can, no one has to appear. Notice what happened. To the sole respondent, so-and-so awaited.
Lordship.
Tracking report is also done, indicates delivery was confirmed. It was tracked and then it was found that the delivery was confirmed, but then the service report is still awaited.
Lordship.
Okay, we will await for some more time.
Lordship.
I heard Mr. So-and-so for the state, but does Mr. Public Prosecutor for the state? Office note dated 25/6/2025 reflects that the service report upon the sole respondent is still awaited. Although the office report dated 16/5/25 reflects that the tracking report indicated confirmation of the delivery of the service on the respondent on 28/3/2025. As such, the registry is directed to do the needful in getting the service report in respect of the sole respondent. Since it is confirmed, why they have not, let the registry do the needful.
Lordship.
List the matter after 2 weeks.
For orders, item number 9.
May it please, Lordship. Lordship, on the last occasion, that is 2nd June 2025, this court has directed the public prosecutor to obtain the case diary of the matter.
Yes, there is there.
Yes, Your Lordship.
This is
However, Your Lordship,
question.
the service upon the respondent number 3, whether it has been completed or not, that has to be checked, Your Lordship, first.
1 and 2.
I'm
on
representing
3.
1 and 2.
Steps were taken on respondent number 3
Written
on the
answer
3rd.
with the marks, no such person in East Police Station or what? This is for quashing of the
For
FIR.
question,
Yes, Lordship.
Lordship.
And
at least-
respondent number 3 is the informant.
Yes, at least
We
opportunity should
can
be given.
appoint one illegal aid counsel.
It's up to the court, Your Lordship.
Right. Heard Miss So-and-so? Instead of again sending it and all, because she was not found, again, some other police station, it's better we hear, because informant is not a very necessary party, but then, okay, she can assist DPP.
Meanwhile, Your Lordship, LCR may be called. I've been informed that it has been charge sheeted.
Okay, it is charge sheeted.
Yes.
Do you need to amend the prayer?
No, Lordship.
Oh, no, and the proceedings thereof. Heard Miss So-and-so for the petitioner and Miss
S. Mary.
S. Meve for the state, APP?
PP.
APP.
PP.
PP. Public prosecutor to the, here
State.
you have so many PPs or what?
We have 4 PPs here.
PPs.
Yes.
Normally, public prosecutor is one and the others are additionals. But here I think 4. There are no
Yes.
additionals.
No additional.
Oh, there are no
Yes.
additionals. Okay, heard PP for the state of Nagaland. The office note dated 16/6/25 reflects that the notice upon respondent number 3, that is the informant, has returned unserved with the remarks that no person is found in East Police Station. Do you have an East Police Station?
Yes, yes.
E-
Dimapur East Police Station.
or Dimapur.
Yes.
No such person is found in Dimapur East Police Station. And the said notice was thereafter returned to the sender. In view of the same, in the interest of justice, this court appoints, give me one name of amicus curiae or legal aid counsel. You have a list? Or you know one?
No, I'm not aware.
Anyone from the court who is
From the
legal aid counsel or an amicus? You're there, huh? Mr. So-and-so with this court appoints Mr. Okay, Jacobi as the legal aid counsel. You are legal aid or amicus?
Legal aid.
Legal aid counsel to appear on behalf of the respondent number 3. List the matter after. Oh, yes, the papers, the relevant papers may be served upon Mr. So-and-so by the register. List this matter after 3 weeks. Any interim order? No, no?
No interim.
Actually, there was a prayer for stay of the proceeding.
No, there was a prayer, but
Yeah.
no interim order
Yes,
passed.
no interim was granted.
After he used, so
Yes.
everything, we can dispose it of finally.
Much obliged.
Grateful, my lord. For others, item numbers 10 and 11.
There is again a delay.
Lordship, delay of 6 days and I believe the
Matters.
different matters.
There also 60, here also 60.
Yes, but I received the brief on the same day, that's why. Yes.
You'll object?
No,
Or you'll
I-
not object?
yeah,
No, you're for?
I'm appearing on behalf of Mr. Imtiwapang.
The
He's the counsel
claimants,
for the claimants.
Claimants.
Yes, Lordship.
And who are the other respondents?
4 and 5 are the driver of the vehicle and the owner of the vehicle.
Return service report are still awaited.
Still awaited, Lordship.
4 and 5, you're not 4 and 5, right?
No, Lordship.
She's 1, 2 and 3,
So 4 and 5 are the drivers.
driver and the owner,
Owner.
Lordship.
They are the claimants.
Yes, Lordship. And the claimants want to
When did
file
you,
objection.
when did you take notice, steps?
Lordship,
6/5.
accept,
Okay,
Lordship,
we can
so-
wait for some time.
Lordship.
I heard Mr. So-and-so for the insurance company and Miss So-and-so for respondent number 1 to 3. The office note dated 25/6/2025 reflects 25/6/25, no, reflects that the service report upon service on 4 and 5 are still awaited. Since the steps were taken only on 6/5/2025, await for the service upon respondent number 4 and 5 further. Listed after 2 weeks.
Bless my lord.
For others, item number 12.
Again, 2-3 service report is not complete. But then delay is only what?
57 days.
57. Acha. You are for the insurance company. You are
For the claimant, for the claimant.
claimant. So
One-
the numbers of the respondent are what?
1 to 3.
1 to 3?
Yes.
2 and 3 are awaited, it's written. Now that you are appearing. There are only 3 respondents.
Yeah, yes.
You are appearing for all the 3.
Yes, I'm told.
Okay,
Yeah.
you are appearing.
Yes, Lordship.
Oh, then it's okay, then it's fine. Here, otherwise it's written not. It's okay. Otherwise, respondent number 1, the report came as unserved. You are sure you are appearing for 1 to 3?
Yes, Lordship.
So that the service is complete now.
Yes, your Lordship.
You can, you will file objection to the
Yes,
delay.
Lordship. Yes, Lordship.
Acha. Okay, heard Miss.
Lordship, if the extra copy of the petition may be served.
I heard Miss So-and-so for the insurance company. National Insurance, right? National Insurance Company Limited. And Miss So-and-so for respondent number 1, 2, and 3. You have filed wakalat number?
Yes.
No, wakalat number is filed only on behalf of 1. 2 and 3 you have not. You file it? You
Yes,
file it?
Lordship. Yes, Lordship.
Miss So-and-so states before this court that she'll be appearing for all the 3 respondents. That is respondent number 1, 2, and 3. And that she will file wakalat number for respondent number 2 and 3 within a period of 2 days, within the course of the day?
Lordship,
2
weeks.
days, within a
weeks.
period of 2 days.
Lordship, 2 weeks.
No, wakalat number
Oh,
of 2 days, then you file your objection in 2 days.
All right.
2 days. She further submits that she may be allowed some time to file her written objection to the interlocutory application filed for condoning a delay of 57 days. Prayer is allowed. List this matter after 2 weeks. In the meantime, the counsel appearing for the petitioner may serve extra copies upon respondent number, extra copies upon all the respondents. You serve 3 copies of whatever is.
Much obliged.
For hearing, item numbers 15 to 17.
You want to do it today? Otherwise, notes were prepared by
Yes, at certain point of time, some judges has been
honorable
here, but
judges.
then
Yes.
it has released. My lord, here, in this read petitions, the crucial aspect is to look into the law, question of law, how the Lokayukta has exercised the power. That is one aspect which this honorable court has to look into. So I may be allowed to submit on the question of law first. The question of law involved in these 3 read petitions are similar.
Same.
Yes, same. Now,
Which
Your-
one will I take it first?
113.
113. 113K, right?
Yes. My lord, the impugned order is at page 57 and next year 25.
$57.
Yes, my lord. Now,
You want to do it for final hearing today?
yes, my lord, if the court is willing,
Otherwise, it's pending for long, it seems.
yes, my lord.
pending for since 10. Okay. 2010.
No, 20.
20.
Yes.
Oh, it seems like 10. Okay. Yes, page 57.
Yes. So this is the order which has been issued by the passed by the Nagaland Lokayukta
Hmm.
in connection with this is case in connection with RC2 of 2013, my lord.
Hmm.
Now, this RC2 of 2013, it has been disposed by the State Vigilance Commission. The disposal of the case was made on 2019.
31,
2019.
2019
Yes, it was disposed of.
by vigilance.
Yeah, by the State Vigilance.
Hmm.
Now, this particular order, which is imbued before the Honorable Court, is an order dated 9/12/2019.
1912.
Yeah.
Hmm. Hmm.
So we are assailing and challenging this order, which has been passed by the Nagaland Lokayukta. Now here, there is a gross violation of the Lokpal and Lokayukta Act 2013 and the so-called Nagaland Lokayukta Act 2017, my lord. Where there is a violation, I would like to point it out before the Honorable Court. Section 9, it speaks about the matter not subject to investigation, and more particularly section 9(3)(a) and B envisage about the period of limitation
Wait,
to.
1 second.
Yes,
This
ma'am.
is impugn order. This is not very long. You can just read it so that I can know.
Yes, my lord. Then I may be allowed to read out, my lord.
There are so many orders of what?
The number of pages is quite voluminous, but anyhow, it will be very easy to understand also.
Acha, acha. Just to give me a brief, what is exactly this order is?
Yes, my lord. Here, there was a criminal trial, and the criminal complaint was lodged by the Undersecretary to the Government of Nagaland BWD Housing Branch, saying that there was a rampant condemnation of government quarters by the person who were alleged as accused in this case by engineer, one engineer and another is two. So
Rampant what? What
Con-
quarters?
condemnation of government quarters, that is PWD quarters.
Hmm.
So after
Destruction of quarters. or
yes,
what?
my lord, action and salvage all this. Now the case was proceeded. After proceeding for the case, the accused were acquitted in the case. Not a single government employee was convicted in this case.
Hmm.
After that, when the case was already been closed by an order dated 31/2019 by the State Vigilance Commission, how this Lokayukta by Somuto taking up the case on 19/12/2019 has revived the case, because the order clearly indicates that as per the bird eye view of this Lokayukta, he has come to a conclusion that in the chart, which has been reflected in these charts, these are the government quarters which has been condemned. Then there are other charts. If your lordship, you can turn to page 61. This is this charts indicates about regularization of land patas, issue of land patas. Then at page 62,
How are you affected?
my lord, here,
How are you aggrieved?
yes, I'm aggrieved because I was neither a party to the proceeding before the trial court in this criminal trial, that is RC1 of 2013. I was neither witness nor my name has been reflected as accused in the case. My land document was seized by the investigating agency during the course of the investigation of this RC2 of 2013. On the basis of the investigation conducted by the IU, my land record documents, as they have insisted, I have handed over the land documents to them. Now, by this order 19/12/2019, I, without giving any opportunity of being heard, violating the principle of natural justice, says that I've been holding a cancelled land pata. I've been holding a land cancel pata.
Cancel land pata.
Yes, but as per my personal inquiry and investigation in last year, it is still ended that my land pata has never been cancelled. Now, by this order, I've been directed, by this order, the Deputy Commissioner, respondent number 3 in this case, has been directed to take action by to cancel the land pata. But the reports indicate, as per the finding of this Lokayukta, they are saying that my land pata has already been cancelled.
Has been cancelled.
Has been cancelled, my lord. If your lordship may kindly turn to page 48. So page 49. Page
48.
yeah, 48. Annexure 20.
Hmm.
The name of the petitioner is reflected, it's serial number 3, Your Honor, my lord.
Yevika.
Yeah, serial number 3, Pendang Meren.
Or not 2. Bendangren.
Pendang Meren, serial number 3, serial number 3.
Hmm. Hmm.
So the occupant is in possession of a cancelled pata.
One second. Hmm? Yes, what?
Serial
This
number.
is the show cause notice.
Yes, this is show cause notice.
Hmm.
And it was issued on July 2020.
The occupant is in possession of a cancelled pata.
Yes.
Okay.
Now, this notice was issued by the Deputy Commissioner, respondent number 3 on 15 July 2020. I'm saying that this particular show cause notice was issued after the expiry of the limitation of the time prescribed under the Nagaland Lokayukta Act. Even the order 1912-2019, which is passed by the Nagaland Lokayukta Act without going through or without recommending the matter to the government, he has just issued an order in direction giving to the respondent number 3 to take action. So Lokayukta is only an authority who is supposed to give a recommendation to the government as to how the case should proceed or as to how the government should take action. But by this order, 1912-2019, Lokayukta has given a direction to the respondent number 3 to take action and to cancel the land patas.
No, here it has been reflected that your land, you are in possession of a cancelled pata.
That is
Again, they have issued orders for cancelling the pata.
Yes, and at no point of time, at any point of time, I have been issued with any show cause that or notice that my land pata is about to cancel or my land pata has been cancelled. No,
This is what? This is show cause notice is there?
Yes, this is the show cause notice which is based on the order dated 1912-2019.
Ah, okay.
So the finding arrived by the Lokayukta by order 1912-2019 is, I'm saying that it is without going into any proper investigation in inquiry, just basing on the proceeding initiated in RC 2 of 2013. And after disposal of the case, the Lokayukta reopened the case and he has passed this order. That is what I'm trying to bring it out.
Achha, show me that previous order 31.
Yes, it is, my lord, the very particular vigilance order we don't have, but I believe this honorable court has at one point of time given a direction to get the LCR from the concerned court below. But here I would like to
Might be here.
page 59 of my repetition. I'd like to just come to the relevant part. I may be allowed to read out.
Yes.
Order. In view of the aforesaid fact and circumstances, the prosecution had failed to prove the charge for the offense punishable under section 409 IPC, read with section 13 subclause 1C and 2 PC Act 1988 against the accused person, namely Srimati Engineer Gauhati Sima. The accused is hereby acquitted from the liability of the offense labeled a cancer. And the meantime, the accused shall execute a bill bond of rupees 1 lakh with surety of a like amount who shall be a government servant serving within the jurisdiction of this court. The accused shall be required to appear before the higher authority in the event as and when such court issue notice in respect of any appeal or petition filed against this judgment. The bill bond shall be enforced for a period of 6 months. The registry is to draw the bond as provided in form number 45 of the Code of Criminal Procedure and execute the bond accordingly. Judgment in order is pronounced in my open court and in presence of the parties given under my
So
hand.
here, Mr. Kahuli Sema was acquitted.
Yes, my lord.
I'm yet to understand a basic thing, like now what do you want to show?
Yes, my lord.
What is, till what I could understand is that Lokayukta's order is bad,
Yes, illegal.
without hearing you and all that.
Yes.
And, okay, then place your case.
Yeah, so given under my hand and seal of this court, I have signed and delivered judgment on this the 30 January 2019. So the entire context, how the vigilance tribunal has conducted the case, how the judgment was pronounced, that we don't have, I don't have.
This is the order where vigilance had,
No, the Lokayukta has make a reference.
okay,
Yes, it is only a partial reference, I believe.
the entire order is not there.
Yes.
Okay, then,
Now, here, just below this also, my lord, it is very relevant also. Mere perusal of the Honorable Court's Order 31, 2019. See, it is just mere perusal. Reveals that the Department of Work and Housing branch, the state of Nagaland, state government, sorry, has not precluded from taking suitable action to recover loss caused to the government by the two officers named above. That means one is Engineer Gauhati, the other one is one, I could not remember, but he was expired at the time of the trial. So whether by coming to this peer perusal of the judgment in order dated 13/1/2019, whether the Lokayukta can reopen the closed case. That is one aspect that this Honorable Court has to take into consideration. It is just peer perusal. Then on page 60, accordingly, the Department of Work and Housing is hereby directed, see, this is a direction in order, directed to verify the buildings yet to be dismantled by the allotee out of the 42 right-of building mentioned above and cancel the dismantle order issued by the then STU H3 and EAH Dimapur. Rework out the depreciation value of the building already dismantled and ensure deposit of the amount through challan to the government. Write to the Deputy Commissioner to cancel bata or allotment order issued against the empty plots / land of the dismantled PWD building. Verify and identify the allotee to the of the contempt building and to serving PWD officer, employees and serving government servants of the other department who has connived to get the allotment order of the dismantled building and land in their name or their kids in can be punished as per the rules of the government. Verify the remaining standing PWD quarter at PWD Colony Dimapur by a team of senior officials for work in housing department, housing branch, along with the Deputy Commissioner or his representative, RO, TC Office Dimapur and LRSU Dimapur to determine the number of standing buildings at PWD Colony Dimapur, encroachment, illegal occupation, etc., and to find ways to stop unauthorized dismantling of PWD quarters in allotment of the emptied land in future. A copy of this order.
Sorry for the interruption, Your Lordship. Yeah, I also want to know the issue which has been raised by the petitioner, subject to correction, if I've understood correctly, the issue which has been raised by the petitioner, subject to correction, whether after closing the criminal case, Lokayukta can open the investigation.
this is what the case is
Yeah,
projecting.
I think that is the issue.
That is the issue, but
Because I also want to understand because I
that's why.
Whether he can reopen and
Yes,
give these directions.
close of the investigation.
Yeah, so I'm saying that there is no scope in the Lokayukta Act to reopen the case, but just to highlight the facts, I'm saying that this particular order 19/12/2019 is a direction in order. So there is no authority with Lokayukta to give direction in order. He has only right. He has a jurisdiction in power to send a recommendation to the government. That's what I'm trying to highlight.
Show me the powers of the Lokayukta. Of
Yes,
course, you proceed as you want, but then
Yes. Section 9.
wait, a Lokayukta Act do we have? Nagaland Lokayukta. What?
I'm sorry, I was on the impression that the court might.
Now I can get a photostat copy of.
No, Your Worship, I have.
Us.
If my learned friend for the time being share.
What is your prayer in this petition?
Yes, my rear in this petition, writ petition is to quash and set aside the order dated 19/12/2019 and the shoe cause issued by the respondent number 3. That is the ground alone. Section 9, Your Honor, my lord, matter not subjected to investigation. There is one aspect. And section 9(3)(a) and B envisage about the period of limitation to entertain.
Which one you are 9? Which one? 3.
Yes, 9(3).
Subsection 3.
A and B.
Oh.
The Lokayukta or the Lokpal shall not investigate any complaint involving a grievance made after the expiry of period of 12 months, limitation from the date on which the action complaint against becomes known to the complainant. So this particular aspect, I'd like to illustrate, my lord. The issue of condemnation, the issue of the land pata to the petitioner was long back. 12 months has already been passed. But it was brought to the notice of the State Vigilance Commission only on 24/9/2013 by writing a complaint.
24/9/2013. What state vigilance? What did you say?
The State Vigilance has received a complaint from the additional secretary to the government of Nagaland, PWD Housing. That was the first complaint. But I'm saying that within the clause of the section 9(3)(a), the limitation has already been expired. That's what I'm trying to highlight to the court.
So the Lokayukta will not investigate any complaint involving a grievance after a period of 12 months.
Yes. Number P, any complaint involving an allegation made after the expiry of 5 years from the date on which the action or conduct complaint against is alleged to have taken place, provided that the Lokayukta or Upa Lokayukta in the respect of grievance or allegation as the case may be, may entertain a complaint made after the expiry of the said period if the complainant shows sufficient cause for not making the complaint within the said period. Now, the order, the main case, that is RC2 of 2013, based on which the case was registered and the investigation was conducted, and the verdict has already been pronounced.
Where one is acquitted and the others not.
Criminal liability against this dead person was already been brushed aside. So when we speak of the deceased person. Now, this particular reopening of the case, if the Lokayukta was to reopen the case also, it should come by way of a complaint by the complainant. But it was never been come by way of complaint before the Lokayukta to revive the case, nor the state government or the complainant, they have preferred in appeal, review, revision against the order dated 31/2019, which was passed by the State Vigilance Commission. So on 19/12/2019, how the Lokayukta, without receiving any complaints from the complainant nor by the state respondent, how he has revived this case. That is one aspect. So it is part by limitation. That is what I'm trying to make out before your lordship. Now,
What
coming
is section 8? What he can investigate?
section 8. Matter which may be investigated by Lokayukta or Upa Lokayukta. Number 1, subject to the provision of this act, the Lokayukta may investigate any action which is taken by or with the general or specific approval of the state, the chief minister or the minister or secretary, a member of the state legislature. Number C, vice chancellor or registrar of a university. Number T, the chairman and vice chairman, by whatever name called, or a member of an authority, board, or committee, a statutory or non-statutory party, or a corporate established or under
It's
any
okay,
law.
it's okay.
Yes,
Here he can investigate any action with the approval of these persons.
yes, my lord.
Then two, Lokayukta may, if it
Yes.
thinks fit, investigate an action taken by or with the general or it is referred to him. If it is referred to him, okay, that is not a case.
Yes,
The Lokayukta may, for reasons to be recorded in writing, investigate any action which may be investigated by whether or not a complaint has been made to the Lokayukta in respect of such action.
yes.
This three may come.
That's why.
Investigate any action which may be investigated by so and so, whether or not a complaint has been made or not.
That is
But-
one part.
Hmm.
Anyhow, but here,
Hmm.
a closed case, a disposed case, how the Lokayukta, by assuming a power, can come to the extent of passing the order 19/12/2019 without giving an opportunity to the petitioner or any other person. Because even without giving any opportunity, the order was passed and the respondent number 3 has acted on the basis of the order passed by the Lokayukta. And the Lokayukta order is very clear. It has been directed that within 90 days, the action taken report was to be submitted to the government, and the government was supposed to take appropriate steps. It is reflected on order. But I'm saying that the shoe cause notice issued by the respondent number 3, 20 July 2020, it was initiated after a lapse of 90 days as per the prescribed period of the Limitation Act and as per the direction given by the direction in order given by the Lokayukta. So respondent number 3 has also acted after the lapse of the specific period given by the order. Section 12, clause 1. Section 12, clause 1. I may be allowed to read out, my lord. Procedure in respect of investigation. Number 1. The Lokayukta or Opal.
Which one? Which section?
Section 12.
12.
Yes. Yes. Clause 1. The Lokayukta or Upal Lokayukta shall, in each case, before it decide the procedure
This
to be.
is for procedure.
Yes,
You are on the jurisdiction itself, they cannot take up.
yes, but since
But
so many implication has
Hmm.
now gross violation has been committed, unless and until I satisfy this honorable court.
Acha, these procedures were also violated.
Yes, my lord.
Even if they start investigating, they should have gone through
Yes,
this.
all this.
This also they have not done.
It was not followed. Section 4.
But first point, whether they can investigate into a closed case,
No, there is no scope.
whether there is any, let me hear the other party,
Yes.
whether there is any scope.
Yes, yes.
That is your only case.
Yes, that my case is how the Lokayukta has reopened the case and passed the order 19/12/2019. And had he, assuming that he has the power to reopen the case, why did not the procedures which has been laid down by the provision has not been adopted and followed?
Section 12. Let me hear him whether Lokayukta has power
Yes, my
to
lord.
investigate. Okay, yes, Mr.
May I please lordship? Lordship, may I take your lordship to the Lokayukta Act.
Yes, I have.
Section 35.
Section?
35. your lordship. Oh, not 35, your lordship, I'm sorry. Lokayukta Act will be. Saving. Section 36, 3, subsection 3,
Repeal and saving.
lordship.
Repeal and saving.
Yes, repeal and saving. Because I'll be coming to Vigilance Commission, Lokayukta and Vigilance Commission. I'll be taking your lordship to that. All inquiries and investigation and other disciplinary proceeding pending before the Nagaland State Vigilance Commission and which has not been disposed of shall stand transferred to and be continued by Lokayukta as if they were comments before him under this act, because this case originally was taken up by Vigilance Commission, Your Lordship. So by virtue of this, whatever cases were pending before Vigilance Commission, it was taken over by local.
This has come into effect when?
Yes, Lordship.
This is
This-
23rd Jan 2018.
Yes.
Okay.
Now, so this is the handbook, Vigilance Commission.
You can say.
Regulation, page, Lordship, mechanic, turn to page 6. Page 6, this is the regulation issued by the Director of State Vigilance Commission, Your Lordship. Now, relevant para, I'll just take Your Lordship to relevant para. Para 5. Para 5, fourth line from the bottom. Even if the Lordship has got it, even if the criminal court acquits the delinquent officer of all the charges, it shall be open to the authorities to make departmental inquiry into the charge and come to its conclusion on the available materials, Your Lordship. So that criminal case was closed against those accused person, but the issue which is raised by the petitioner, after closing of that criminal case, how can this investigation go? The criminal case was closed by the special judge, not by Vigilance Commission, Your Lordship. Now, para 9. The tribunal or the head of department conducting an inquiry shall, on completion, submit the inquiry report to the Vigilance Commission. The Vigilance Commissioner thereupon, on a scrutiny of the report, recommends to the concerned secretary to the department head the punishment to be inflicted on the delinquent officer. Now, Your Lordship.
No, you have to make a distinction between criminal case
Yes.
and departmental
So,
proceeding.
so by that, because whatever proceeding was before the Vigilance Commission, that was the departmental proceeding, Your Lordship. Now, a criminal case was also registered that was taken up by the special judge, Your Lordship. Now, on examination of the whatever PP based on the evidence, the special judge acquitteds the accused, Your Lordship. But that does not closes the departmental proceeding, Your Lordship. Yes, Your Lordship. Now, so the departmental proceeding will come to end only on submission of the recommendation. Now, for that, may I take Your Lordship to the Lokayukta Act. Section 25.
Lokayukta.
25 Lokayukta Act. Report of Lokayukta or Lokayukta. Now, Your Lordship, as per the record available, no recommendation, no report was submitted by the Vigilance Commission in respect of this inquiry, except for the fact that, yes, that criminal case was disposed by the special judge, acquitting the accused. Now, Your Lordship. So it is for the Lokayukta. Now, till the report is submitted by the Vigilance Commission, the matter is pending with the Vigilance Commission.
And
Now,
it will get transferred to
Lokayukta, and it is for the Lokayukta to submit the report. Now, Your Lordship. Section 25, subsection 3, relevant. If after investigation of any action involving an allegation, because this is an allegation where some irregular pata was issued, Your Lordship. The Lokayukta or Lokayukta, as the case may be, is satisfied that such allegation is substantiated, either wholly or partly, he shall by a report in writing communicate his finding and recommendation along with the relevant documents, materials, and other evidence to the competent authority concerned. Now, with due respect, Your Lordship, the submission which has been made by the petitioner that after closure of the criminal case, no further investigation, it cannot be reopened. I don't agree, Your Lordship, because investigation before the Lokayukta, earlier Vigilance, this thing, will come to an only on submission of the recommendation to the department, Your Lordship. And this is by the impugn order here, what has been done is Lokayukta has submitted its recommendation.
Listen, in fact, there are two parts. Now,
There are two
it's
parts.
Actually,
Yes.
what you are saying is that he is mixing up the two. It's not opening criminal account. That is gone.
That is
That is separate. Here, vigilance was inquiring, and then it got transferred, and then
Yes.
Lokayukta can
Yes.
give a report.
Criminal case acquittal, that is different, but the special judge, that is different.
That is what you want to say.
Yes. So there is no, it's not legally sustainable, the submission which has been advanced. Your Lordship.
This is okay. He has a point. In fact,
I
it's
can-
not reopening your criminal case where you were acquitted or what?
No, I'm saying that even my name
Ah.
was not been listed in the FIR, nor my name has been charged, put in the charge sheet, nor I've been made as a witness in this case, in the criminal trial. It was decided by the Special Judge Vigilance Commission, so the chapter has already been closed. If,
But in the directions you are aggrieved.
yeah, I'm saying that it should not by way of an order in direction, because the Lokayukta can give a recommendation to the government or to competent authority. The competent authority will take decision what to
In
do.
fact, that is what is done.
Yes,
Why, if
but-
we have
but
shown
here-
the directions.
Your Lordship, here the issue which has been raised by the petitioner, if I have understood correctly, is as per the act, Lokayukta can give only direction, only
no.
recommendation, not direction.
Yes.
So that is the issue, whether Lokayukta can give direction, that is the issue. But in my respectful submission, so far as this is concerned, no direction has been given. It is only recommendation, but Lordship.
But
In fact, the one that you had shown me at page 60, accordingly, accordingly, the Department of Work and Housing is hereby directed.
So it is
It is
direction.
not recommendation, you are saying these are directions.
Yes,
And here you are aggrieved.
yes, my lord.
Which part? That to identify the condemned building?
My lord, to that I'll come. My lord, see here. Page 61.
Hmm. Yes.
61, the second part of the chart, middle part of the chart, serial number 29. My lord.
Yes, 29.
Yes,
29 is?
serial number 29, revenue 4/87 dash.
That is your land.
Yes, this is the land, how it was been regularized in my name. And if I come to the facts, this particular land I purchased in the year 2020. Prior to that, there was another land owner. Till then, no issue was raised by the government at any point of time. Only after initiating of this criminal complaint, RC2 of 2013, the issue has come up, and only after the disposal of the case and after passing of the order 19/12/2019, I came to learn that I'm holding a cancel land patent. Otherwise, at no point after, nobody has ever disturbed me saying that by issuing a notice or by issuing summons, nothing was done. Even during the course of the investigation of this criminal case, I was asked to produce the land documents, which I had.
Yes, it's already one.
Yeah, so
It's
shall we
one.
continue
After break, we will
At
continue.
2 o'clock, we will
Yes,
start
ma'am.
again.
All right.
At 2 then. This is the only matter I think left.
Lordship.
Thank you. Yes.
Yes. May I continue, Your
Yeah.
Lordship?
Just show me from your pleadings, like what exact case have you made out? Have you stated about the show cause notice and all?
Yes, my lord.
Show cause notice was
Issue.
before 1901,
Yeah. No, after.
1912.
No, after that only. 1912, 2019 was the passing of the order by the Lokayukta. And by that order, the Deputy Commissioner was directed to take action. So before taking action, the Deputy Commissioner has issued
Show cause.
the show cause notice that is on July 2020. So the show cause issued by the Deputy Commissioner itself from ab initio is, I'm saying it's illegal. Because had the order dated 1912-2019 was not in the form of direction, but it was in the form of recommendation to the appropriate authority. The appropriate authority may decide in what way the issue may take.
Where do we find that it can be only in the nature of recommendation or direction?
Yes,
Where
my
it is in the act?
It's
Whether the direction can be considered as recommendation only?
Section 25, subsection 3, Your Lordship. I have taken Your Lordship to that where Lokayukta can make recommendation.
Yes.
After investigation of any case?
Yeah.
The Lokayukta, as the case may be, if he satisfied such allegation is substantiated, he shall by a report in writing communicate his findings and recommendations
Yes.
along with so and so to the
Competent authority, yes.
So here although the word is direction, it can be recommendation also.
My lord, your lordship, sorry, I will come to that.
Ah.
There are two part of the order, two part, your lordship.
Acha, one party can finish and the other not like.
No, yeah, just,
Okay.
May I take your lordship to the impugn order?
Yes.
Page 57, your lordship. Lordship has,
60 other directions, 57.
yeah,
59.
page 57, your lordship. Your lordship has got it. This is the. Lordship has got it. It starts with part 1.
Huh?
Immediately after date 19/12/2019, part 1.
Part 1.
Yeah. Part 1, rampant condemnation and dismantling of PWD quarters at Dimapur. Now, may I take your lordship to second part? Second part starts from 61. Page 61. Lordship,
Irregular use of patta.
this is irregular issuance of patta, regularization of. So there are two parts. The subject matter, there are two subject matter. Investigation was done, your worship. First part is regarding rampant condemnation of government quarter. Second part is irregular issuance of land patta. Now coming to the first part is the direction is at page 60. Page 60. Just top two line I read, your worship.
Yes.
Accordingly, the Department of Works and Housing branch is hereby directed to. And here I have considered, your lordship, as several writ petition was filed, writ petition 208 of 2021 and other link cases, 16, 17 cases. I considered so far as part 1 is concerned, yes, Lokayukta cannot give any direction, your lordship. But so far as the second part is concerned, that is irregular issuance of patta, which this case relates to, your lordship. Now, on recommendation, may I take your lordship to page 73. Now, starting from page 61, your lordship, Lokayukta has made observation. And finally, page 73, your lordship, below the column, the table. Before any recommendation is made, your lordship, first part, direction was given. So far as the second part is concerned, part 2 is concerned, before any recommendation is made, some further observation relied upon some notification issued by the government, your lordship, and page 75. In bold, your lordship, DC Dimapur is to take action such and such and such. That is part of the recommendation, your lordship. And next para, it is recommended that the department. So far as second part is concerned, in my respectful submission, your lordship.
But it is whole part, right? Dimapur is to take.
These are the recommendation.
Patta.
Yes.
May take action as mentioned.
Thorough verification.
Through verification.
And to make this verification, your lordship, show cause notice has been issued. And that show cause notice has been challenged here, your lordship. So there are two parts of the order.
Again, it is recommended.
Recommended, your lordship.
Headed by so and so allot system.
Yes, LRSO, because the RO revenue officer, because it relates to irregular issuance of land patta. And here the competent authority, your lordship, may kindly see section 25, subsection 3. It is not government, competent authority. And under Assam Land Revenue Regulation Act 1886, which is applicable in Dimapur, your lordship, RO is the competent authority, your lordship. So far as issuance of patta is concerned. So two parts of the order. So not direction. So far as direction is concerned, in earlier writ petition, batch of writ petition relating to condemnation of PWD quarters, your lordship.
As far as part 2 is concerned, there are no such recommendation in tabular form. What you have shown is
no direction, only recommendation. No.
Have shown is what page?
Page 73.
73
Huh.
is
Imi-
in respect of part B,
Part B, part 2.
regularization extension orders by so and so.
Yeah, irregular issuance of pata. And we are concerned with part 2 of the order here, Your Worship. So far as this repetition is concerned. In fact, Your
When
Worship,
directions in part A affects him.
no, Your Lord, because that relates to different subject matter. This
But he says that affects him.
no, because so far, even if it affects them, Your Lordship, that has been cautioned set aside. So far as condemnation of quarter is concerned, that is totally a different subject matter, Your Lordship.
How can you say that this is
Yes.
only in respect of part 1?
Which one, Your Lordship?
That the directions.
The direction? Because part 1
Oh, yes, part 1 is, oh, yeah, part 1 ends here.
ends here,
And
61.
then part 2 starts.
Yes.
Part 2
And
starts.
part 1, he said that these has been already set aside.
Yes.
Very much.
In
So
other cases,
in, yes, in part 1.
part 1.
Part 1. So part 1, my name is, petitioner's name has been clearly reflected.
Part 1.
Yes, part
Where?
1, yes. Serial number 10, it is in connection with writ petition 2 of 2021. Serial number 2, part 1. In the first page, that is page 57.
Huh.
So serial number 10, it is in connection with the petitioner.
But then it said that notification, that direction goes.
Yes, I agree, Your Honor, my lord, I agree. Now, this part he has already considered. Okay. If we go to the part 2, even my name is also been reflected in the part 2.
And those are recommendations.
And those are recommendations. Now, I would like to come to that point, my lord. There is an order passed by this honorable court. I'll come to that point, yes, my lord.
And where is that 19-1 order? Just give me this. That acquittal order by court.
Acquittal is that special judge.
Ah.
Worship that's but
That can be in the, this one.
yes, it must be there.
In order to reflect that in my judgments, I want.
Lordship,
special.
Lordship.
Your junior can see in these records, if that order is there. Huh. This is those writ petitions.
Yes, so it is connection with the same connection with the order 9/12/2019.
Mhm.
Here, my lord. Relevant portion is at para page 24.
Paragraph.
Yes,
Paragraph.
para 1, 2, 3, 4, 6,
all.
it's reflected on the top where I relied also. So I may be allowed to read out this paragraph because it is a clear admission on the part of part 1. My learned senior friends has already admitted. Now I'm coming to part 2. This entire list of the writ petitioners are falling under part 2.
Part 1.
No, this entire writ petitioners falls under part 2.
Sir.
Yes.
For allocation of land and pata, those ones.
Allocation, yes. And so I'll come into that point. So relevant para, I'll come 1. Let me be allowed to read out.
The same Lokayukta's order.
Yes, yes, yes. And it was disposed on 35/2024. Sorry, yes, 24. May I read out, Your Honor? My lord, all these writ petitions being analogous, which have put to challenge an order dated 19/12/2019 passed by the learned Upa Lokayukta Nagaland, followed by an order dated 17/9/2020 passed by the concerned Public Work Department. These are taken up for analogous hearing and are disposed of by this command judgment in order. Para 2. Before going to the issue which has risen for determination, it would be convenient to narrate the fact of the case. However, since the challenge is structured mainly on the point of law, this court may not be required to record the facts in detail of each of the cases. Para 3. The petitioner in these cases are the beneficiaries of certain actions of the Public Work Department pertaining to the certain quarters in the area commonly known as PWT colony.
Part 1.
Yes.
PWD
Yes.
quarters. Okay.
Yes.
It is the contention.
It is the contention of the petitioner that the quarters were constructed long back in the year 1968 to 1969 and were in stipulated condition. Under two circumstances, the department had taken a conscious decision to dismantle the building. Accordingly, the salvage material were put to action in which petitioners were the action purchaser. The consideration paid to the department has also been demonstrated by way of necessary receipts. In some petitioners were also allotted the land on which the quarters stood. See, that is one point where they claim to have made construction and residing therein with their families. This is very clear, my lord.
This is part one only, the consideration paid to the department.
Yeah. So, but
in the same petition, petitioners were also allotted the land
yes,
on which the quarters stood.
yes.
Right.
So a land was allotted by the revenue authority to the petitioners over which the building was constructed. Now, those building has been auctioned. Now, it covers the part two. And this, the entire writ petition which has been disposed by this command judgment, it is reflected in part two. That is what I'm trying to make it out. Paragraph 4.
How can a PWD land be allotted to a private person?
That's why, my lord.
Is it the law here? It can be done over.
There should be certain procedures to be followed.
Achha, okay.
And after following the procedure, it can be allotted to the private individuals or any other persons. Procedure has to be followed. At a later stage, I'll come to that point also. But here, instead of prosecuting these officers who has allotted the land, government land to the individual or any person, they have never take action despite of the office memorandum in notification out in public domain. The state government, they have never take into account of those memorandums and recommendations, office memo. The same situation now prevails here. And in the Lokayukta order, he has reflected this panning all in that. And if whoever officials, public officers, does not follow the office memorandum guidelines or whatever, they were supposed to be punished. Yeah. But instead of going to that extent and jumping under midway, now the petitioners, they are trying to prosecute. That is what I'm trying to make it out in this case.
Then?
Yes. Paragraph 4 of the judgment, however, pertaining to a vigilance case which was instituted in the year 2013, which culminates in an order of acquittal of an existing officer, the Obal Lokayukta had passed an order dated 19/12/2019, making certain direction for cancellation of the aforesaid orders, followed by an order 17/9/2020 of the department of such cancellation. It is contended that both the aforesaid orders were passed without giving the petitioners an opportunity of hearing. Para 6, relevant. The learned counsel for the petitioner has submitted that the decision to dispose the salvage materials and also for allotment of the land after such demolition was taken by the department by following a due process of law. Reference has been made to an inspection report dated 3/11/2021 by the department, whereby no objection was conveyed to public action. Pursuant to the same, the direction was issued on 4/11/2021 for disposal of the salvage material by the executive engineer to the STUBWT. Consequent thereto, the salvage materials were put to action which were purchased by the petitioner by making the necessary deposit. The learned counsel has also referred to an order dated 5/11/2011 to write off the materials. So far as the land after the demolition of the quarter, the same was also allotted to the same petitioners, where, as indicated above, construction has been made and the said petitioners are residing with their families. Para 7, the learned counsel has referred to the complaint dated 24/3/2013 by the Work and Housing Department telling to registration of the vigilance case. Consequently, a criminal case being RC2 of 13 was registered before the special judge after trial. However, by judgment in order dated 31/2019, the existing executive engineer was acquitted. And so far as the other accused were concerned, namely the STU, he had passed away during the proceedings.
it is highlighted that none of the petitioners or their spouse who were government servants were made accused in the said criminal case. It is submitted that upon the passing of the aforesaid judgment dated 31/2019, the proceeding initiated had culminated as there is no further appeal. However, the Lokayukta White Order dated 19/12/2019 had reopened the matter and passed direction for cancellation of the dismantling order and also the orders of allotment of land. It is submitted that the aforesaid order was passed without affording the petitioners any opportunity of hearing. Consequently, the department-wide order dated 17/9/2020 had cancelled the right-of order dated 5/11/2021, which consequently affected the order of purchase made by the petitioner in action in also regarding the allotment of land. This is submitted that even the order of the department was passed without giving opportunity of hearing or any notice. Number 8, by drawing the attention of the court to the Nagaland Lokayukta Act 2017, the learned counsel for the petitioner had submitted that under this act, the Lokayukta has power only to make recommendations. However, by the impugned order dated 19/12/2019, direction has been given for cancellation of the right of order as well as the land as well as the allotment orders, to emphasize that the contents of the order dated 19/12/2019 was in the form of direction. The learned counsel has drawn the attention of this court to the subsequent order dated 15/5/2020, 26/5/2020, 28/8/2020, whereby the direction was asked to be complied with the report thereof be submitted. 9. On the aspect of the violation of the principle of natural justice, the learned counsel for the petitioner has submitted that it is an admitted position that at no point of time the Lokayukta had either issued notice nor given any opportunity to the petitioner before passing the order dated 19/12/2019. The same procedure was also adopted by the department while passing the impugned order dated 17/9/2020. As no opportunity was granted to the petitioner, it is submitted that the impugned order of the Lokayukta dated 17/12/2019 in the order dated of the department dated 17/9/2020 are not sustainable in law and is liable to be set aside in quash. Yes, then the relevant portion, if your lordship may kindly turn to page 30, paragraph 16. Yes. The root of this case is a communication dated 24/9/2013 by the Work and Housing Department to the Vigilance Department, as observed above. Based on the said complaint, a criminal case was registered under Section 409 of the IPC read with Section 13 Clause 2, Subclause C and 13(2) of the Prevention of Corruption Act. It is to be said that in the aforesaid proceeding, the present petitioners or their relatives who were government servants were not even made accused. The said proceeding was against 2 officers, namely one STU and 1 executive engineer. The judgment dated 31/2019, which reflects that during the proceeding, the concerned STU has passed away insofar as the other officer was concerned, namely the executive engineer, he was acquitted. It is not in dispute that the aforesaid judgment had attained finality and no appeal was preferred by the state. 17. This court has also taken note of the fact that the complaint was lodged in the year 2013 in the Lokayukta. Nagaland Lokayukta had come into operation in the year 2018 in accordance with the Nagaland Lokayukta Act 2017. Though reliance has been placed on Section 36, Clause 3 of the Act, this court is of the considered opinion that it is only the pending matters which would be transferred and continued by the Lokayukta, and such matter should be pending before the State Vigilance Commission. There is nothing in record to even suggest that the proceeding was pending before the Nagaland State Vigilance Commission, and rather the judgment dated 30/10/2019 would demonstrate that the proceeding which was initiated had culminated. Under these circumstances, the action of the Lokayukta to reopen the matter is itself a matter of debate. And in the considered opinion of this court, the jurisdiction exercised by the Lokayukta in reopening the case by taking recourse to section 36, clause 3, as submitted appears to be itself erroneous. 18. So far as the condition that the Lokayukta had issued a direction, the learned counsel for the Lokayukta had fairly conceded that though the expression directed has been used, it should be construed as recommendation. The court would also agree to the submission made by the learned counsel for the Lokayukta that since the function of the Lokayukta is to make an inquiry, there may not be a mandatory requirement to give any opportunity to concerned party. Para 19. The aforesaid requirements, however, would be a mandatory requirement so far as the action taken by the administration is concerned. In the instant cases, the order dated 17/9/2020 passed by the department is admittedly without any notice or opportunity. This order having adverse civil consequence upon the petitioner, the department was
17/9 or what? 1912. Oh.
17/9/2020.
Acha.
The said order having adverse civil consequence upon the petitioner, the department was under the legal obligation to issue notice and to give effective opportunity to the petitioners to defend their case. On this count itself, the impugned order 17/9/2020 is unsustainable and accordingly set aside. Para 21. Under the facts and circumstances aforesaid in the discussion made, this court is of the considered opinion that
1912.
the impugned order dated 19/12/2019 passed by the learned Lokayukta, so far as it constitutes a direction, is unsustainable in law. Further, the consequential action taken by the department in the form of order of 17/9/2020 is unsustainable and accordingly set aside. So this is the common judgment in order passed by the Honorable High Court or Honorable High Court.
Where
So,
it is said that reopening by the Lokayukta is debatable and it
yes,
appears to be erroneous.
yes.
Just an opinion, opinion.
Then,
My contention in this case is that in part one, the Lokayukta has considered the names which has been now listed in this command judgment in order. There are about 18 to 19 petitioners. They are all reflected in part two. Part two. And even the petitioners, 3 petitioners before this honorable court for hearing today, they are enlisted in part two also. So I'm both be affected by part one as well as by part two. That is what I'm trying to propose to.
but part one, okay, part one, you are there, your name is there.
Yes.
But part one, of course, that cannot be a directions as held by this court.
Yes.
So that was said to be wrong.
Yes.
This order is said to be illegal.
Yes.
17/9 order also goes.
Yes.
And here part 2 is not touched. Part 2 is, of course, part 2 is in the form of a recommendation. And after that, show cause was issued. You replied, show cause you replied.
Yes.
Show cause you replied.
Yes.
Yes, petitioner has replied, but before DC could dispose it off, they have approached this. That is the issue. Let DC dispose of the
No, my lord, but here,
You have an alternative and again you have approached this court.
no, my
You
lord,
have made recommendation for disposal by DC.
no, here, what I'm trying to make out to this honorable court is that they have enough remedies. The complainant or the state government has enough remedies to go ahead with the case. After the disposal of the criminal case, 31/2019, either by revision review or
No,
what.
that they did not.
That
they did
that
not
part
approve.
they have
That
not approached. Yeah, it ends
That
finality.
is case,
Yes,
which has attained finality, people were acquitted.
yes.
Now here, this is actually in the shape of a departmental inquiry where it is inquired by the Lokayukta.
No.
It was
Loka-
first inquired by
Lokayukta-
the
Lok-
vigilance.
Yeah, it was inquired by the vigilance and disposed by the vigilance.
They disposed by vigilance on 1912.
No, 30.
No, 31.
Yes,
30th of January, it was disposed of by vigilance.
Yes.
Where is that order? 31?
my lord. We have just a part and parcel of the order, which is.
That
been
you had
reflected.
shown.
Yeah, but the main judgment.
No, that you had shown. Where is a part and parcel of 31?
Yes,
You
part
had
and
shown
parcel.
court judgment.
Yes. Now, after that,
No, just show me 31 vigilance order.
Yes. Page 57, the main portion, but if your lordship turns to page 59.
But this is what you have shown, that is
Yes,
criminal
so
case.
apart from that, the petitioner, we don't have the entire context of the judgment. How it was disposed by the Vigilance Commission, special judge.
This is by Vigilance Commission.
Yes,
Okay.
yes.
They had disposed it off.
Yes,
They have acquitted.
yes.
And
Now,
what about the court case with the judge?
Your lordship, this is not by Vigilance Commission, your lord. Special judge
the vigilance.
by, this by a special judge.
Special judge,
Yes,
Vigilance Commission.
yes, yes. This by a special judge.
Yes.
This is by special
Yes,
judge,
yes.
Vigilance Commission.
Yes.
And then
After that, the Lokayukta has never initiated any inquiry. No inquiry. It was just based on mere perusal
of these orders.
of the earlier order. So page 59, last paragraph, it is very clear, my lord.
But they have also inquired, see the
No, no,
language
no.
during the verification of the occupants of PWD quarters and so and so.
My lord, that is wrong. That is wrong. At no point of time inquiry was conducted by the Lokayukta. They just relied on the documents furnished by the IO in the vigilance case.
But then see but then see page number 61, part 2 means I'm talking about part 2.
Yes.
There some inquiry was done on scrutiny of so and so.
No, my lord, I'm saying that this is totally misleading. This is totally misleading. No inquiry, nothing was conducted. This is a totally misleading.
But I will go through the papers now, and paper says that some inquiry was done. See two, the status of so and thereafter. And Lokayukta can inquire into anything as you have shown from the act
My lord, that's why.
without there being any complaint or anything.
Here, my case is that Lokayukta, yes, I am presuming or assumes that the Opa Lokayukta or the Lokayukta can reopen the case.
It's not reopening the case. It's like inquiring into the
Okay,
matter.
okay, can inquire. All right, I accept to that point. But I'm saying that at no point of time, not a single investigation was conducted, but the entire findings given in this order, 1912-2019, is based on the documents furnished in the vigilance case. At no point of time, the Opa Lokayukta has initiated any inquiry by giving order or direction. It was relied on the peer perusal of the earlier judgment. That is what I'm trying to say. So, yes, with or without authority, I'm saying that there is no power. But assuming that there is a power to conduct inquiry by the Lokayukta, Section 12 was not followed, 14 was not followed. Yes.
Procedures were not.
Procedural. The entire,
Let's see what procedures. Section.
yes, yes. Section 12, my lord. Section 12.
Lokayukta shall in each case decide the procedure to be followed by making an inquiry.
No,
In his own discretion at any stage refuse to inquire or cease to inquire any complaint involving allegations. Okay. And the mayor has the power to review his order or decision to restore any. See, section 12, subsection 1.
Yes.
The Lokayukta shall in each case before it.
Yes, decides
The procedure, decide the procedure to be followed by for making the inquiry, and in doing so, ensure that principle of natural justice.
That was not done.
That you were not heard.
Yes, then coming to 2. The Lokayukta or Opa Lokayukta may in his discretion or at any stage refuse to inquire or cease to inquire into any complaint involving a grievance or allegation. It is
fictitious.
if
It
in
is
his
frivolous,
opinion.
vexatious.
Yes, so
or
C
ground
is very
concerning
important. C
other
is very
remedies.
important. C.
Other remedies.
Other
like that.
remedies. So what remedies the state has taken or the complainant has taken, that has to be looked into. Because they have so many remedies, but they have not exhausted even a single remedy.
and issued the order dated 19/12/2019. That is what it happens here in this case. Then, my lord, I would like to take your lordship to this section 25 also, wherein my learned counsel has also relied. I'm also relying on this also. The relevant portion is 4. Number A, the competent authority in the case of public functionary other than the chief minister or the minister of the state legislature shall examine the report forwarded to it under subsection 3 and without any further inquiry take action on the basis of the recommendation and within 90 days from the date of receipt of the report, intimate or cause to be intimated to the Lokayukta or Upalokayukta as the case may be, the action taken or proposed to be taken on the basis of the report. So nothing was, no recommendation was sent to the authority concerned. Prove it that they have sent it.
No, they shall examine the report forwarded to it under subsection 3.
Yes.
If after investigation of any action involving an allegation, Lokayukta is dissatisfied wholly, he shall by report communicate its findings, recommendations. Okay. So after that, the concerned
Yes.
authority shall examine the report and without any further inquiry, take action. So this has been done.
No,
This
that
has
is not
been done.
complied.
Ah.
Then 5, clause 5.
Hmm.
If the Lokayukta or the Lokayukta, as the case may be, is satisfied with the action taken on proposed to be or proposed to be taken on his recommendation referred to in subsection 1 or subsection 3, he shall close the case under information to the complainant, if any, the public functionary and the competent authority concerned. But where he is not satisfied, and if he consider that the case should deserve, he may make a special report from the case upon report upon the case to the governor and also inform.
This will not come in your case.
So this
Your
procedure.
case is these are all subsequent actions.
Yes. So here, all these procedures which were supposed to be followed by sending a recommendation, the Lokayukta can take action, but not a single course
No,
of.
you are making two arguments. First one is that Lokayukta cannot
Yes.
sit
Yeah.
upon the judgment of the special judge vigilance. And secondly, you said even if they had
Assuming.
the twofold arguments, in
Yes.
fact, you have.
Yes.
Assuming they have not followed the procedures.
So I'm saying that the order dated 19/12/2019 is totally ultra vires in gross violation of the act. And
1912 is otherwise stated to be erroneous by unsustainable by the learned single judge.
yes, my lord.
First part.
Yes.
First part of what?
Second part. First part, it is already been considered.
Because it seems it is in respect of first part.
No, my lord. I'll indicate that how it is connected.
The impugn order in 208 petition relates to first part, condemnation. The impugn
This is what prima facie seems.
Yes.
But he's saying that it is
Here the impugn order is different.
I'll point out that difference.
79 is not in respect of this. Where is 79 order?
79.
You have annexed 79 order?
No, but in fact, even the order from the order itself, it will be 79.
79 order is not there. This is in respect of the first part. Let me see 17.9 order.
17/9 order.
Your
Since
lordship,
I was not the party to the.
your lordship may kindly take the writ petition, the order dated judgment order 35/2024.
That one I have seen.
Page
Has he quoted?
page 26. Para 7. 7 line from the bottom, para 7. Consequent thereto. The department, that is the Public Works Department, by order dated 17/9/2020, this is the impugn order, has cancelled the writing off. So it relates to the cancellation, that condemnation of.
Yes, that part is, I agree also.
Writing of order dated 5/11. Where is that writing of order 5/11?
that by this right of letter, your lordship, that quarters were condemned.
Salvage.
Acha. That is also not there in this proceeding.
No, this is different. This is totally.
So what he is saying that this is in respect of part one only.
Yeah, but I'm saying that it also covers part two. So I'd like to bring out the difference.
Covers part two, then your case is settled. This is gone.
That's why I'm saying that the order itself is illegal. So I'd like to bring out the difference, my lord. If your lordship will kindly make a reference to the order dated 35/20/24 first page. First page.
Yes.
Yes, serial number 1, read petition number 208 of 2021. If your lordship may kindly turn to page 66.
Hmm. 66?
Yes,
There's no page 66 here.
66
Oh,
of,
66.
yes.
66, yes.
Serial number 3. Serial number 3 in the table.
60.
Last column.
After 64 or just. Oh, 60, what did you say? What page number?
Page 66
Oh.
of my read petition, my lord, of my read petition.
Of your read petition.
Yes,
66, yes.
yes.
Hmm.
Last column, number 3, PW 65. That is quarter number 65 is equally and serial
No, which
number
one?
1.
Which quarter number 65? Page number 66, right?
Yes, last column, last.
Yeah.
So serial number 3, it is in connection with the read petitioner and 208 of 2021. It is part 2. This is it from the part 2, my lord.
The last one, you mean PW 65?
Yes. Vikas
Fully.
Himumi.
Vikas Himo.
Yes, so the read petitioner is in the order passed on.
Vikas Himo. This
Yes.
is Vikas Himoni. Ocha.
Yes.
Regularization given in a central land against village file.
Yes. Now, the next, kindly turn to page, I'll take your lordship to second page. Link case, WC 290 of 2021. Second page, my lord, second page of the
Second
judgment.
page.
So serial numbers, page 66, serial number 1. So it's from the part 2 list.
Where
Then
did you get that linked case 290?
link case 290. It is the name is reflected as Tulamenla, the petitioner's name.
Tola Menla.
Yes.
Tola Menla is where?
Tulamenla is some other person, initial, but Tulam, wife of late Emily Thompson. So the serial number 1, page 66, in the low part of the column is Emily Thompson.
Emily Thames.
Yes.
This is Tola, oh, acha, wife of.
Yes.
Hmm.
Then your lordship, you kindly turn over to page 5. Link case is 295.
Acha, what you mean to say, the petitioners here are also there.
Yes, part 2. Part 1, the Lokayukta has considered, but the entire list of the petitioners in the order passed by this honorable court on 35/2024, and my case is in part 2. So when the part 2 by the order dated 35/2024 has said that the order 19/12/2019 is totally illegal, why my case should not?
You mentioned all this before in your reply, show cause reply.
Show cause reply in that point of time, all those records were not been provided to us. My my land documents, everything was seized by the Lokayukta.
See, your reply is pending before the DC.
Yes.
So let that reply be disposed of, only then I can take it up. Otherwise, there are 2 remedies going on.
Very much, that's why. So here,
Or I can say the deputy commissioner to finally dispose of your reply, to consider your reply and dispose of the case. Then you can come to it. Now this is premature.
My lord.
There is already one remedy availed by you.
here, what I'm trying
When you
to.
challenge the cause, show cause, as
Yes.
well as the order,
Yes, ma'am.
without filing any reply, then the matter would have been different.
But here, I'll explain the thing. why the petitioner has very urgently approached this honorable court. Though it's not in the record, but the petitioner has already learned that the forceful eviction was to be conducted. So having no other alternative option, approach this honorable court, at least to stay.
Where is
And-
that? Those pleadings are there.
Yes. Yes, page 15 of my writ petition, my lord, para 18.
Yes.
I may be allowed to read out. That the petitioner respectfully submits that as a duty-bound citizen, the petitioner, in response to the Shiuko's notice dated 15/7/2020, has also submitted a written reply supported by all relevant documents. However, in the event that respondent number 3 in exercise its power and recourse, if taken as per direction of the impugned order dated 19/12/2019, the petitioner is highly apprehending the future course of action likely to be used in initiated by forceful means to dispose the right of ownership. As such, the petitioner files this instant petition before this honorable court, praying for sitting aside in quashing the impugned order dated 19/12/2019 and the Shiuko dated 15/7.
And this was filed in 2020.
Yes,
Till now, nothing has happened.
nothing has happened.
DC has also not,
Hmm.
Dr. Shawka's reply was not considered. Now this, now giving a writ here, when your reply is pending will not be proper. So let them dispose of the notice, you consider your reply, and you have to file something more, you can file more. Because you had not given for full details, full events. So I'll make an order so that the deputy commissioner disposes of, and if you're not satisfied, come to the court.
But had this writ
Because
peti-
many years, it's not like yesterday it happened.
Yes.
So many years have
But-
gone by.
So many years has gone by, but now, my lord, I'm here, the petitioner has already constructed their own residential building here, residing there. If the government takes a different, the deputy commissioner takes a different record, then the petitioner will be highly,
Then you can come.
but
Who
he,
bars you? But fact of the matter is that the second part is in the nature of recommendation, not even in the nature of
Lord,
directions.
that,
You are involved somehow in the first part. That is we are saying.
yes,
Yes. And first part too, you have an order of this honorable court.
my lord, then I'll come to the crucial part after this case.
You place this order before the deputy commissioner. Right, this order, where it is said that this is erroneous. There is a obiter dicta, even if it is not ratio decidendi. Right, you can place this and then you can, I'll give a direction for early disposal of that. And then if something happens, you come. Otherwise, there is something there where you have availed your remedy. Here also there is something.
Why the petitioner has taken such immediate steps is
That
that,
we
that
did.
I've already indicated.
Yes, that you have indicated, but then that was 5 years back.
Lordship, that was 5 years back. In fact, in the para 18 also, they have mentioned that apprehending of a
But the
future course
finding-
of action likely to be used.
Yeah,
Likely,
likely, but it is still
Used also till date.
because of the stay order, my lord, because of the stay
There is a
order.
stay
Yeah,
here.
because of the stay order, the action was not initiated. Otherwise, it would initiate.
No charge.
Yes. Now, just I leave it to the wisdom of this honorable court, but how they come to a finding that I have been holding a cancel land pada? That is the finding given by the Lokayukta. Till there, as per my physical verification of the records lying there before the revenue authority, my land pada is ended. So all this false finding has been given in this report, order.
Okay, that let the DC take care and then you come. I'll dictate the order. Let's see what it comes out. Okay. Oh, no, doesn't. You have also challenged the virus of some ultra virus.
Yes, my lord, because the Lokayukta,
Then it should have come before the division bench. You have challenged the virus of Lokayukta Act.
Yes. Virus, otherwise, I see that they have,
The virus attack has not been challenged.
It's
The
in
only
the cost
extent has
list.
been violated.
yeah, violated.
No, see the cost item, see the, cost in the prayer is not there, but in the cost title it is there. Ultra-virus, to declare it ultra-virus.
Act of the Upal Lokayukta, action of the Upal Lokayukta.
Action.
Yeah.
Ultra-virus act of.
Upal Lokayukta, that is the member. There is the order of the
Oh,
Lokayukta.
acha, acha.
Yes. My lord, if my prayer may be considered at this stage, this, your lordship may give a direction to the respondent number 3 or the state respondents.
You are
Okay.
appearing for respond number?
Yes. But if this writ petition we keep pending or appears still the disposal of my writ petition, that will be more appropriate because the petitioner all through this year, they are having some.
Keep it pending will not suffice because disease order will be what? There you have to again amend and everything has to be done afresh after so many years.
Or your lordship, subject to what my friend says, if he has the apprehension, your lordship, till such time the deputy commissioner disposes of it, he should not be disturbed. His position.
Yes, that undertaking I'll get it from him.
If that is the case.
Okay.
No.
The, this is a petition filed under Article 226 of the Constitution of India, as well as Article 227 of the, Article 226/227 of the Constitution of India. Challenging for a writ for issuance of a writ to set aside the impugn order dated 19/12/2019. You can set to this. Wherever there's some mistake, you can just let me. Okay. 19/12/2019 passed by the Lokayukta, Nagaland, Kohima in RC number 2 of 2013 and registered under section 409 420/120B IPC. Full stop. The petitioner had also challenged the impugn show cause notice dated 15/7/2020 issued by the Deputy Commissioner, Dimapur, Nagaland, in pursuance to the impugn order dated 19/12/2019. It is the case of the petitioner that the Lokayukta, wide order dated 19/12/2019, had issued certain directions as well as recommendations in respect of 2 inquiries conducted by him.
Lord, it should be state vigilance, not by the Lokayukta.
Inquiry.
Yeah, inquiry was conducted by the state vigilance, not by the Upal Lokayukta.
And now Lokayukta.
Now Lokayukta, I'm referring of 1912. The order dated 1912 makes it 1912 makes it clear that the same were passed in respect of 2 issues. One, in respect of rampant condemnation and dismantling of PWD quarters at Dimapur, and irregular issue of patta, comma, regularization of land, extension and mutation of patta in the PWD colony, Dimapur, by the office of DC Dimapur. In respect of the first part, the Lokayukta, after considering, after a preliminary inquiry, after an inquiry, as well as upon consideration of various orders, have issued directions as mentioned here in below. You quote this, huh? A to A. These are the directions. A to A, huh? A to A here, not here. A to A, huh? I mean the bolded portion. Have passed this field, has passed these directions. And in respect of part 2, the Lokayukta, on the basis of an inquiry, where are the recommendations of part 2? You have shown page 73, but then it is written before any recommendation is made.
Yes, and then
Few relevant notifications.
notification.
Okay, where are the recommendations?
a recommendation, page 75, starts with bold.
Oh, yes. And in respect of part 2, recommendations were made by the Lokayukta in page number 75. Huh? There are 4 lines. You can B from B, B to B. It is apparent from the directions given in respect of part 1 that the Deputy Commissioner was directed to cancel patta or allotment of land, allotment order, to cancel patta or allotment order issued against the emptied plots or dismantled PWD building.
May I interfere with the duopoly? I think it should be part 2, not 1. If I'm not
No,
mistaken.
this is part 1.
Part 1 is for condemnation of water, my lord.
These directions are in part 1
For condemnation.
for condemnation.
Not for allotment of
But
land
then it
patta.
is also written there.
Yes, that's why. Either way, my case is affected.
I will tell that your case in fact falls under both the parts.
Yes.
As well as to verify and identify the allottees of the condemned building and serving officers who had connived and got the allotment order be punished as per rules of the government. And in the part 2, the DC Dimapur is directed to take action on the cancellation of patta. And after verification, streamline the system and submit a report.
Your lordship, subject to correction, your lordship, it should not be direction, it should be recommendation. Lordship.
Recommended. What did I said direction?
Yes.
Was recommended, not directed. Yes. Was recommended. The learned counsel for the petitioner states that RC case number 2 of 2013 was initiated against 2 officials and the trial was conducted under section 409 IPC. There was a trial, right?
Yes.
409 IPC read with section 13(1)(c) and 2 of PC Act 1988. And conducted, and on conclusion of the trial, the accused person, one accused person was acquitted, and the other, what happened?
Expired. One EE, executive PWD department, and one SU, because they have met that condemnation order. Regarding
Those details.
yes.
One was acquitted, and the other
Expired.
had expired during the trial. And that other expired during the trial. And the judgment was delivered on 30th of January 2019. And that there was no appeal or revision against the said judgment. And as such, he submits that the said judgment had attained finality. However, the Lokayukta had reopened the said judgment along with other also, no? Yes. Along with other, what are these notifications that he has considered? Condemnation of buildings only.
Yes.
Survey reports.
Allotment of government land.
Okay. So what he said, judgment, reopened the said judgment passed by the Special Judge Vigilance Commission and passed the impugned order dated 19/12/2019. Which, according to the learned counsel, is not permitted under the law. He had placed section where he cannot order, where he cannot act, which one?
Act 9, 12, 9, 12, 14, 25.
He had placed section 9 of the Nagaland Lokayukta Act 2017. And by placing subsection 3 of section 9, he argued that any complaint that Lokayukta cannot investigate any complaint involving a grievance after the expiry of 12 months. As well as any complaint after the expiry of 5 years
Any comment involving allegation. Grievance is different, allegation is different, Your Worship.
involving an allegation of grievance.
Yes.
And the first one you write grievance.
Grievance
After 12 months
and
and allegations after 5 years.
Your Lordship.
Any complaint involving allegation after expiry of 5 years.
But this is a case so far as investigation relating to irregularizations of Pata. This is not based on complaint, but so moto in the course of the
Yes. However, he also stated that in the proviso, that limitation period can also be extended if sufficient cause is shown. He also placed what sections?
12.
He also placed section 12
One.
of the said act, wherein it is provided that a Lokayukta on his own motion may make a preliminary inquiry.
Section 8, subsection 3.
11 provides for a preliminary inquiry section. Subsection what? 8 you said?
My lord, section 12, subclause 1.
No, I'm placing his portion. I'll place yours also.
Yes, mine is section 12, subclause 1. Then section 12, sub 2, subclause C.
Okay, then 11, yes, make such preliminary inquiry as it deems fit. And if on such preliminary inquiry, he finds that some grounds exist, he can record a finding to that effect. And what else we have placed?
Section 14, clause 1.
Full stop. He also placed section 14, clause 1 in order to establish the fact that establish the law that
It is
so these are procedures.
yeah, procedure. So
That we say, he had also placed section 14 in order to establish the law that the Lokayukta has to follow certain procedures which was not followed in the instant case
No,
while passing the order dated 19/12/2019.
Your Worship, just one clarification on that. In fact, petitioner relied on section 12, saying that principle natural justice was not followed on 12. But section, in my respectful submission, Your Lordship, section 12 relates to investigation. Supposing if petitioner is being investigated, but this is a case where neither vigilance nor Lokayukta investigated against the petitioner, no investigation was conducted against the petitioner, but under section 14, Lokayukta can collect evidence,
but that was also not been done. That is what I'm saying.
And to collect evidence, he was asked to produce the pattas, land documents. He has done it.
No, my lord,
So
that is
for that, natural justice is not necessary, Your Lordship.
my lord,
No,
that is,
I'm recording
is a
whatever he's saying.
here I'm saying that the Lokayukta has passed the order 9/12/29 day based on the evidence in documents collected in the vigilance case. Lokayukta has never conducted any inquiry, investigation, nor has directed any officer to collect evidence.
On his own motion, he can inquire. That is provided in 14.
14, but certain procedure has to be followed.
That's what I have said that those procedures were not followed. He had also placed one judgment passed by this honorable court, wherein wherein the said order dated 19/12/2019 was declared to be unsustainable in law. However, the same is in respect of part 1 of the order dated 19/12/2019. Not however, which was in respect of the right.
Lord, I mean, with the ability, my submission is, it covers part 2.
This one I'll say. The Mr. So-and-so appears for the petitioner, submits that the petitioner is affected by both the parts of the order dated 19/12/2019. As his name appears in serial number 21, right? In serial number 21, in part 1 and serial number 29 in part 2 of the said order. He also submits that in the order dated, Achha, that one I did not give the order date, right? The of this honorable court. There you write the date is 30/5/24. That the order where it was held to be unsustainable. Yes, 30/5/24. He had also stated that by the order dated 30/5/2024, his cause was also involved in the said order. Your cause is also there. These are your submissions, Radha.
Yeah. So,
On the other hand, if you remember something, let me know. On the other hand, Mr. So-and-so, I don't.
I'm TB Jamir
TV Zamir.
for respondent number 4.
And all the respondents are.
Yes, for state respondent, I am for Lokayukta.
Yes. So-and-so, appearing for respondent number 4, the Lokayukta submits that the case of the petitioner is included in part 2 of the order dated 19/12/2019. And the said order and the said part, and in the said part, it is apparent that the Lokayukta had conducted an inquiry and had given a recommendation in respect of the said issue in question. The recommendation was annexed at page 75, wherein a notification was issued on 18th of August 2011. No. Recommend in pursuant to that recommendation, this notification.
Based on the notification.
Based on the recommendation.
Based on the notification.
Based on this notification, yes, recommendation, yes. And recommendation was issued, was given to the Deputy Commissioner to take action on the cancellation of Patta in accordance with law. No, in accordance with law, Kato. After conducting a thorough verification.
Yes. So, and accordingly, DC has issued a so-called notice after conducting the investigation, Your Lordship. May I take Your Lordship to DC's order, page 48. Relevant page 50. This is the show cause notice. Page 50.
50.
Yes, just below the table. Lordship has got it. So further this office after
This is
scrutinizing
the
and
show cause notice.
yes. So further this office after scrutinizing and verifying all documents and record, this is as per the recommendation of the
Full stop. In view of the said recommendation, the Deputy Commissioner had issued a show cause notice on 15/7/2020 to the petitioners as well as others to appear in his office with all relevant documents in support of the claims. Full stop. In pursuance to that show cause notice, the petitioner had filed a show cause reply,
page 77.
page 77, has filed a show cause reply on
There is no date, but your lordship, page 77, there's a seal on the left hand side, bottom.
when did you file the reply?
There it is written 14/8, I think
My lord.
14/8/2020.
The reply was filed just after few days because yes, it's indicated in the seal, it's 14/8/2020, round seal in the first page.
Round seal is there.
Ground seal is there, but in my copy, it's not in full. The circle is not full. On what date I'll give? During
14/8/2020.
14/8/2020. 14/8/2020. Immediately 1 month after the answer. He further states that the said reply is pending consideration before the learned Deputy Commissioner, Dimapur, Nagaland. Where was the show cause notice you had just shown? 45?
Page 48, my lord.
48.
Yes. 48 to 50.
It is noticed, para, it is noticed. You had placed something from the act. What did you place? What had you placed? You had placed something from the act.
From the act,
What sections you had placed?
I have relied on section on reopening of case. Regarding that, I've relied on section 25, subsection 3.
Before that, it is noticed, before it is noticed. The Learned Council relied on section 25 of the Lokayukta Act of 2017.
Yes. So investigation culminates only on submission of recommendation. Closure of criminal case, that is different.
You have placed section 3, subsection 3.
Yes, 25(3). If after investigation of any action involving an allegation, Lokayukta, as the case may is satisfied, the allegation is submitted either wholly or he shall be.
There's section 25(3) of the Act, wherein it provides that if the Lokayukta, upon an investigation into an allegation, is satisfied that an allegation is substantiated, wholly or partly, he can file a report.
Yes. And an investigation comes to an end with the filing of the with the report.
And the findings and recommendation, and that the investigation comes to an end on filing of the report.
Yes, Lord. And then report is to be submitted
So you
to,
have said,
report is submitted to the competent authority. And then so far as allotment of land is concerned, Your Lordship, under the Assam Land Revenue Regulation Act, RO, which is the Deputy Commissioner, he is the competent authority.
and he also he also had placed subsection 4, where it is said, the competent authority shall examine the report and he, without any further inquiry, can take action on the
Yeah.
basis of the recommendation.
But in this case, Your Lordship, without further inquiry, he can take action. In fact, the Deputy Commissioner Dimapur has issued a show cause notice. That's my recommendation.
But however, he also stated that in the instant case, although the competent authority can initiate action without any inquiry, but in the instant case, the Deputy Commissioner has, after receiving the recommendation, had issued show cause notice to the petitioner and others before taking any action.
And Your Lordship, so far as on limitation is concerned, section 9, 3A and B, which is related by the petitioner, Your Lordship, this is related to complaint. But there is a case where in the course of investigation on rampant condemnation of government building, Your Lordship, Lokayukta has come, it has been brought to the knowledge that some irregular allotment of patta also has been issued. So section 9(3) is not attracted here, Your Lordship, because under section 8, subsection 3, Lokayukta Somoto can also investigate.
He also states that the limitation period, which is his submission.
My
But
submission.
to keep in mind, I'm saying that this Lokayukta Act, it is confined with PC Act 1988. So PC Act 1988 has to be treated in this case. But what my learned senior friend is saying that time limitation under section 9 of the Act says that it does not attract. I'm saying it should attract because it is the Lokayukta Act itself is to proceed under PC Act 1988. So what PC is prescribed accordingly.
Those things should be taken care of, but then yes, prima facie this thing. So he also states that that the limitation period as prescribed under section 9 of the Lokayukta Act will not be applicable in the instant case, since the Lokayukta has powers provided under section 8 of the said act to inquire suo motu. Then you say.
And Your Lordship, another point, so far as violation of natural justice is concerned, your petitioner was not investigated, Your Lordship, but then only evidence was collected, documents were collected. So the violation of section 2.
Collected by the vigilance.
By the vigilance. So we have taken over. So that the vigilance, whatever.
Vigilance is acquitted.
Yes.
Acquitted, right?
Yes.
Now, Lokayukta has power suo motu, they have inquired. So no, not, and that is a criminal inquiry which is done by them, and this is again statutory, under the statute they can do it. Okay, then it is noticed that in the early part of 1992, various orders, notifications were issued by the government of Nagaland, banning allotment of government lands to private individuals without prior approval of the government. However, it was unearthed that various rampant condemnation and dismantling of PWD quarters were done and lands were allotted. As such, a case was registered being numbered RC2 of 2013 before the State Vigilance Commission. The State Vigilance Commission conducted the trial and acquitted the persons as mentioned above. On the other hand, the Nagaland Lokayukta after a thorough investigation, found out that pattas has been issued to several persons in respect of land belonging to PWD. And they were found in total violation of the notifications, orders issued by the government of Nagaland. And after the said inquiry, the Lokayukta passed the order dated 19/12/2019. In pursuant to which the petitioner, you were declared as an occupant of cancel land by the Lokayukta.
No. My case is that, my lord. Prior to the passing of the order by the Lokayukta or the investigation conducted by the state vigilance, kindly turn over to my synopsis. It's synopsis. Since the court has reflecting about the ownership also, I would like to just come to this point. Synopsis, it's reflected in my judgment petition, but for easy reference.
Make this writ a futile. I'll give something and so that this DC will consider.
Yes,
Where?
yes, my lord, but since 1990s,
Where?
yes.
Which paragraph?
Synopsis at column 1,
Hmm.
first page
Hmm.
of my writ petition.
Hmm.
The original landowner was Siri Temchin Yanger.
Hmm.
And after that, in the year 2007, the land was purchased by the petitioner at one point of time from him. At another point of time, the petitioner has purchased another plot of land adjacent to the area from another person. And all this process of mutation, as per the Assam Land Revenue Regulation Act, all the due process has been done and the deputy commissioner has issued the land patta in the name of the petitioner. And it was paying revenue tax. All the taxes were paying, but fortunately, unfortunately, at one point of time after the allotment, the quarter happens to have stand in the land that has already been in my occupation, the land. So the condemnation was done. That's why my name has been reflected in part 1. So I've also paid the salvage payment, everything, and the salvage has been taken over by me by being through payment through treasury challan.
No, you mean to say you were allotted the plot of land where PWD quarters had come, were raised on your land.
Yes, that is
Then,
that.
thereafter, what did the Lokayukta do?
Lokayukta, he basing on the state vigilance inquiry conducted by the IO, says that I'm holding a cancel land part.
And this is what I'm saying.
Yeah.
This
In
is
writ petition 113 of
Yeah, it is
2020, your
really
lordship,
different.
petitioner is in possession of cancel patta.
Yes.
In writ petition 114 of 2020, your lordship, petitioner, the patta which is held by the petitioner, the patta does not fall in PWD colony, in other
Let
colony.
DC will decide. Let me say,
Yes,
he was in occupation of a cancel patta. This is what it is said.
yes, in
by
113.
the Lokayukta.
113, yes, yes.
This is what. This is what I was dictating. He was in occupation of a cancel patta. Where the what did I say? The first part. Petitioners were said to be in petitioner was said to be in possession of a cancel patta.
This will be common judgment, your lordship. This will be common judgment 113, 114, and 02, because there are 3 matters. So in 114, patta does not fall in PWD colony.
Okay. In the other case, same things will be there.
Writ
but
petition 114 of 2020.
there you say not this one.
Patta does not fall
Patta does not fall
in PWD colony.
land.
Colony. colony does not fall in PWD colony. And in the last writ petition 2 of 2021,
2021.
forced land regularization order.
Forged
Yes.
land. These are the three differences. The third one you write, forged land regularization order.
Order. And the rest will be the same.
It is further noticed that in pursuant to the recommendations given by the Lokayukta, which had resulted in the notification dated 18th of August 2011. No, pursuant to that, recommendations given by the Lokayukta, the Deputy Commissioner issued a show cause notice to the petitioner, to which the petitioner filed a reply. As such, this court deems it necessary that the Deputy Commissioner may consider the reply and pass the final order within a reasonable time period, which may not
Specific time period may be given.
which may not extend beyond 3 months period. The respondent number, the council appearing for respondent number 5, that is the Deputy Commissioner. Oh.
Respondent number 1.
1, 2, and 3, and he is for 4. Acha, acha. 1, 2, and 3. Yes, yes. The council appearing for respondent number 1, 2, and 3 may communicate this order to the Deputy Commissioner, Dimapur, Nagaland, and for compliance of the same. A copy of the petition, the copy of the order may be furnished to the council, Mr. So-and-so, appearing for respondent number 1, 2, and 3. Full stop. And in between, if I say something, some requirements I'll give, the matter is disposed of. If you have any grievance after that, come. Otherwise, 2 images falling into different.
But till then, the disposal of the, yes, that
Till
may
the
be.
disposal of the, show cause issued by the learned Deputy Commissioner, the council appearing for respondent number 1, 2, 3 assures the court that no coercive measures would be taken against the petitioner.
Lordship, would that be the case, Lordship?
Or
Status quo, as of that, Lordship. Since I
I'm
cannot-
disposing it off now.
Lordship, but I cannot assure since I don't.
So till disposal of the so-and-so, the
Direction court may direct, Lordship.
a status quo order, a status quo may be maintained
Lordship.
by all the parties
Lordship.
for the ends of justice.
Much
Petition is disposed of. In between, if something I see, I can write, and I'll let you know tomorrow if I write something.
Obliged.
There are no more matters, right?
Much pleasure.